I've already agreed with you on something.
I wouldn't think that.
Well, good morning, everybody, and I do have to start with a health and safety briefing, as I'm told. Everybody here I know knows where to go. Out the doors at the far end, toilets are out there. We need to meet at the Spates House if there's an earthquake or a fire or any other emergency, and telephones, cell phones off, please. With that start.
Oh, good morning. I do have some legal submissions, which, despite having somehow written to 13 pages, can be reasonably brief for this topic. What those submissions are setting out is simply the legal framework which applies, the impact of that for the structure of the hazards part of this chapter, and dealing with a couple of legal points which arise from submissions on the contaminated land part of this chapter. So turning to my submissions, paragraph 1, that's an extract from the first of the significant resource management issues for the region to do with hazards, and it can be summarised as: in Otago, we are surrounded by natural hazards, and the risks associated with that need to be managed. Turning to the legal framework, as is always the case, everything flows from section 5, and the key part of section 5 is enabling people and communities to provide for their health and safety. We also have a matter of national importance, meaning that the regional policy statement needs to recognise and provide for the management of significant risks from natural hazards. There are a couple of definitions which are relevant. The first is the definition of contaminated land. And I do want to highlight that definition because in considering the contaminated land part of the chapter, it's important to keep in mind that contaminated land is land that has a hazardous substance in or on it, that either has significant adverse effects or is reasonably likely to have significant adverse effects on the environment. So contaminated land is not any land that has some form of contamination. There must be the significant adverse effects or the reasonable likelihood of that. The definition of natural hazard is unremarkable. Over the page, section 30, subsection 1, the functions of the Regional Council, which are relevant to this chapter. I don't think I need to read that in full, save to note that it includes the avoidance or mitigation of natural hazards, and it also includes controlling discharges of contaminants into or onto land, air, or water. And the reason that second aspect, the discharges of contaminants into or onto land, air, or water, is relevant is that generally the adverse effects which arise from contaminated land involve the discharge of a hazardous substance to land, air, or water. And that's why, I'm getting ahead of myself, but I'll flag it now. That's why dealing with contaminated land goes beyond the specific reference in section 31 to the investigation of land to identify and monitor it. Up to paragraph 7, it's just noting that section 62 requires identification of who's dealing with matters concerning the avoidance and mitigation of natural hazards, and that's dealt with in the methods of this chapter. Importantly, under section 62.3, we've got to give effect to the New Zealand Coastal policy statement. Under section 61(2)(e), we need to have regard to the National Adaptation Plan. And under section 61(1)(e), the regional policy statement needs to be prepared in accordance with the Resource Management National Environmental Standard for Assessing and Managing Contaminants in Soil to Protect Human Health regulations. So turning to the first of those higher order instruments, the New Zealand Coastal Policy Statement. Coastal Policy Statement provides strong direction on the management of coastal hazards in the coastal environment. The relevant objective is Objective 5, which is to do with ensuring that coastal hazard risks taking account of climate change are managed. Policy 1 needs to be noted. Policy 1 is the policy that's dealing with the scope of the coastal environment. And at D, that provides that the coastal environment includes areas at risk from coastal hazards. So essentially, if you're in the path of the tsunami, you're part of the coastal environment. Policy 24 deals with the identification of coastal hazards. And in addition to the extract, there is in that policy a list of factors to take into account. Policy 25 then deals with what's to happen to areas potentially affected by coastal hazards over at least the next 100 years. That's A and B in Policy 25, which I want to highlight because those impose avoid standards relating to increasing risk from coastal hazards and avoiding redevelopment or land use changes which would increase the risk of adverse effects from coastal hazards. And I will come back to that. Policy 26 is to do with protecting and restoring natural defences against coastal hazards. And Policy 27 is providing some guidance on dealing with areas where there's significant existing development which is likely to be affected by coastal hazards. And I don't propose to read all that out. Set it all out so it's all there in one place for reference. Turning to the National Adaptation Plan, I've set out the relevant passage from that plan, the guidance which needs to be taken into account in this regional policy statement and other planning instruments is that the adaptation plan is telling us that the minimum climate change scenarios that should be considered. And the passage is the second paragraph of the extract I've included. It should be noted that the National Adaptation Plan, or a National Adaptation Plan, is prepared in response to each national climate change risk assessment. Those risk assessments are to occur regularly at intervals not exceeding 6 years. So within 6 years, you can expect a new national, a new risk assessment and then a new National Adaptation Plan. Turning to the environmental standard to do with contaminated soil. Paragraph 20, that provides a set of planning controls and soil contaminant values to ensure that contaminated land is appropriately identified and assessed before it's developed, and when necessary remediated to make it safe for human use. The land which that standard applies to is land which is on the hail list, or more likely than not to have had a hail activity undertaken on it, i.e. it should be on the hail list. The activities which are regulated are the removal or replacement of fuel storage systems, sampling the soil, disturbing the soil, subdivision, and changes of use. The standard prescribes whether activities are permitted, controlled, restricted, discretionary, or discretionary. And because the standard doesn't say that it's open for plan makers to include more or less stringent rules, that standard must be applied by territorial authorities in accordance with its terms. Essentially, there's a set of planning provisions that are to be applied in the same way nationwide. The standard isn't directly relevant to the regional policy statement. It expressly relates to territorial authority functions and not regional council functions. But the regional policy statement shouldn't be including a policy direction which would require a district plan rule which is in conflict with the standard. And in my submission it doesn't, it's just a point to note when considering any changes or proposed changes. So, that framework can be summarised. So far as hazards are concerned, the regional policy statement should achieve the purpose of the Act by recognising and managing significant risks from natural hazards as a matter of national importance, and more generally by the avoidance or mitigation of natural hazards. The NZCPS gives specific direction in connection with coastal hazards, and that must be given effect to. For all hazards, regard must be had to the National Adaptation Plan, which tells us the minimum climate change scenarios to be used. And I've just noted there that it's preferable not to spell out those actual scenarios because they will change fairly regularly. It's better to signal that they need to be looked at source. And otherwise, we don't have any specific higher order direction for non-coastal hazards. For contaminated land, investigation and monitoring of contaminated land are specific OSC functions. By definition, contaminated land involves a hazardous substance which has or is reasonably likely to have significant adverse effects on the environment. Generally, those effects are due to a discharge of the contaminant to land, air and water, and it's a function of the regional council to control those discharges. And we have the NESCS, which regulates some activity status in the district plan context. You just need to keep in mind that we shouldn't have change which would require a district plan rule to be inconsistent with the NESCS. So that is our legal framework. That has an effect on how the natural hazard policies in the regional policy statement are structured. Coastal hazards are dealt with in a way that gives effect to the coastal policy statement. As a result of that, some policies will apply only to coastal hazards, and some apply only to non-coastal hazards, and some policies apply to all hazards. The policies which apply to all hazards are listed at paragraph 39, just as a point of reference. Policies which are specific to coastal hazards, policy 1A and policy 10. Policy 1A is to give effect to NZCPS policy 24 and subclauses 1, 2 and 3 in policy 10 to give effect to NZCPS policies 25A, B and C. The key thing about this is that those policies are directed towards giving effect to the avoidance standard in the NZCPS. So turning to policies specific to non-coastal hazards, it's policies 1, 2, 3 and 4. There's a different policy set for non-coastal hazards because the approach differs from the mandatory requirements of the NZCPS for coastal hazards. Policy 2 introduces a risk assessment applying criteria which are set out in App 6. After applying the risk assessment and App 6, we end up with a hazard risk which is either acceptable, tolerable, or significant. When dealing with new activities, it's only when the risk is significant that the activities to be avoided. Tolerable or acceptable levels of risk are permissible. This also informs policy 4, which deals with reductions in natural hazard risk, and it is different to the NZCPS avoid standard, which requires an avoidance of increased risk. Here, we've got an approach of assessing risk, including the extent to which it's able to be tolerated, and dealing with the risk in light of that assessment, rather than simply saying no increase in risk can occur. So on the hazard part of the chapter, that's really the only point I want to make, to highlight that distinction and the reason for it, because it makes it a bit easier to follow the chapter. Turning to contaminated land, this is paragraph 53 of submissions. Mr. Callett, who I think is the fuel company's witness, has proposed a new policy in place of the existing policy 15. The new policy is manage the use and development of land for hazardous facilities where analysis demonstrates adequate controls are not provided by other legislation. Such a policy would constrain local authorities in exercising their functions under the Act, and in my submission is ultra vires. That's because it's implicit in the policy that management of use and development of land for hazardous facilities is not to occur unless other relevant legislation is shown to have inadequate controls. If hazardous facilities, for example, have effects on the environment, which it's relevant for a local authority to manage in a plan or policy statement, or in considering a consent application under the Act, then the local authority has to do that, regardless of whether those facilities are otherwise regulated. For example, storage, transport, use of a hazardous substance may be regulated under the Hazardous Substances and New Organisms Act, but it doesn't follow from that the use and development of land for those activities may only be regulated in the resource management context if there's some demonstrated inadequacy in the has-no controls. When dealing with circumstances where an activity is regulated by legislation other than the Resource Management Act, that other legislation doesn't limit the application of the Resource Management Act. Any Resource Management Act jurisdiction issue is determined by reference to the scope of the local authority's functions to give effect to the purpose of the Act, not whether other legislation provides adequate controls or not. Resource Management Act applies in accordance with its terms, and any provision which limits that is ultra vires. I'll just add that while all of that's the case, that doesn't mean that a consent authority, for example, can't consider things like has no controls, and how robust or not those controls are may well be relevant to its assessment of effects in a consent application, and it may also influence whether consent conditions or plan provisions are light-handed or heavy-handed. But the bottom line is that local authorities, where they have functions under the Resource Management Act, must perform those functions. They can't be abrogated on the basis that another piece of legislation also deals with the activity in question. Next aspect is that criticism on policy 15 legal aspects, and that's paragraph 61. So Mr. McCulloch's also criticised policy 15, which he seeks to replace. Policy 15 provides, it is the policy which says that creating new contaminated land is to be avoided, except where that's not practicable, in which case adverse effects are to be minimised to the smallest extent practicable. The reasons for Mr. McCulloch's criticism include that it's unduly onerous, that hazardous substances are widely used by the community, that this is a legacy issue, and that given the definition of contaminated land, he cannot foresee a situation whereby council would grant consent to contaminate land. And it's that last point that the legal submission on, although I've observed that if that's the case, then the policy itself shouldn't be objectionable. Consents for discharges of contaminants onto land can be issued. Relevant references at footnote 12, section 87E. And it's a function of the regional council to control those discharges, which is in section 31. Having a policy which simply says that where practicable, the creation of new contaminated land should be avoided is entirely within scope of the regional council's functions. And it's not really saying anything much more than that so far as possible, contaminated sites should, as Mr. McCulloch says, be a legacy issue, not something we are creating afresh. Now, the second point I wish to address is a point made by DCC's witness, Mr. Taylor, in connection with the same policy, where it is criticised as being inconsistent with LFW policy 15. That freshwater policy, as it stands, prefers the discharge of wastewater to land over discharges to water. Mr. McCulloch references policy 23 of the NZCPS as being more permissive than the hazard policy P15, and suggests that on this basis the proposed regional policy statement would appear to prefer coastal discharge of treated wastewater over discharges of treated wastewater to land, contrary to the direction of the proposed policy P15. The point that needs to be made is that LFFW P15 is concerned with freshwater, not coastal water. And more generally, I'd note that policy 15 is simply the avoidance where practicable of creating contaminated land. Come back to the definition of contaminated land. You need a hazardous substance which is or is likely to have significant adverse effects on the environment. I don't think you can read the preference in LFW P15 for discharge of wastewater to land that it's intended to result in the discharge of hazardous substances having or reasonably likely to have significant adverse effects on the environment. So I don't think there's any inconsistency whatsoever. The final point in the submissions is the meaning of contaminated land. Touched on this at the start. Definition set out in paragraph 4. Key point is that throughout the contaminated land chapter, when provisions are being considered, it's important to have in mind that we're dealing with hazardous substances on or in land which are likely or reasonably likely to have significant adverse effects on the environment. An example of where this might be relevant is has CLP 14, which has also been criticised. That's the policy dealing with management of contaminated or potentially contaminated land so as not to pose an unacceptable risk to people and the environment. And subclause 3, avoiding as the first priority and only where avoidance is not practicable, mitigating or remediating adverse effects of the contaminants on the environment. This means nothing more than the effects of the contaminant on the environment must be avoided unless this is impracticable. For the policy to apply, you need to have or potentially have something which comes within the definition of contaminated land, i.e. significant adverse effects on the environment. So the policy is merely saying that significant adverse effects on the environment from contaminated land are not acceptable if they can practicably be avoided. It's not saying that, or rather it doesn't apply to all land that has some form of contaminant on it, no matter how insignificant. So those are my submissions. Our two subject matter experts are Andrew McLennan and Scott Kelly. Mr. McLennan prepared the section 42A report. Mr. Kelly's provided expert advice for that purpose and written evidence which has been filed. And so when I've answered any questions, I will call Mr. McLennan.
Kieran, I take it Mr. Kelly is on screen.
Thank you, Mr. Anderson. Your legal submissions have helped me to a degree in relation to policy 15 around the contaminated land issue, which is the one we're avoid unless it's not practicable. And I guess the concern that this may actually possibly more for Andrew as well, but that has been raised by submitters and that's been exercising in my mind is the Hale list, which does identify things that, you know, we just wanted to know your view on how they relate, because it does refer to things like, well, it does refer to the waste disposal to land. Also refers to mining industries. But the other one of note is the persistent use of pesticides in market gardens and orchards and things like that. So that avoid policy, I'm assuming, would have an impact in relation to those types of activities, unless it's not practicable to avoid that. In relation to waste, though, then the plan's actually telling you you're not going to do that, you're going to dispose to land. Is that a weird practicable option?
Yeah, In short, yes. So that the policy would have effect with respect to contaminated land that could be created, for example, from mining. But the standard is to avoid where practicable. It's not a pure avoid. And I guess I'd comment that where practicable is not it's not an exceptionally high bar to get over. So it's certainly not remotely close to a prohibition, which is usually the criticism with avoid policies.
Yeah, the question probably was more maybe answered by Andrew later, because how I envisaged, because it would be very unusual for council to control pesticide sprays on viticulture or horticulture, so it'd be probably a permitted activity subject to standard. So that's probably the council's regional plan saying that's fine. You don't have to avoid in that sense, because we've imposed standards of how you do that. That would be how it probably works.
In short, yes, you would expect for activities that occur commonly in particular areas, those would be regulated in regional plan. And the dimensions are, I guess, first of all, for something to become contaminated land, you've got to have those significant adverse effects, not just any effect. And standards would be to ensure that you're not having a significant adverse effect. And we'll speak that to also pick up on the practicability part of the equation.
Although that list doesn't talk about how significant the effect is.
Oh, well, it's worth commenting that the definition of contaminated land is not the Hale list.
No.
So there can be things which are on the Hale list which do not meet the definition, and vice versa.
Yeah, well, I'm trying to work out that relationship, because people look at that and say, well, it's contaminated land. And you have to go through a process because of that. But what you're saying is that policy is not necessarily going to pick up everything on that, because it won't meet that definition.
Yes, so you look at the Hale list, and essentially that's telling you that in normal everyday English, the site may be contaminated.
Yeah.
It doesn't necessarily mean it is contaminated. But being on that list doesn't mean that you are contaminated in the Resource Management Act sense.
Okay, thank you. The only other thing was the National Adaptation Plan. I see that have regard to date has gone by. I'm assuming the RPS was drafted before that. But again, it's probably more of a question for Andrew, but has that been had regard to? And how do you actually do that in an RPS when it changes every 6 years potentially? So it's difficult to do, isn't it? You said, well, you shouldn't have probably written policies in there that mimic it, because it's going to change.
Well, one of Andrew's opening statement points is just that point, and he'll correct me if I'm wrong, but there are words added to Act 6, and now proposed to be further amended, which are essentially a nod to those minimum climate change scenarios in the National Adaptation Plan. Oh, apologies, that's in Mr. Kelly's evidence, not Mr. McLean's.
Okay, thank you.
Yeah, thank you, Mr. Anderson. Alan's pretty much covered off the points that I was wanting to make, or the questions I had. Just in relation to the National Adaptation Plan, though, it's something that I'm not familiar with. There's guidance there, you provide paragraph 18 as to the climate change scenarios. Is that essentially what the the guidance that the adaptation plan provides, and then the councils pick that up and map according to those scenarios. Is that how it works?
In short, yes. I guess firstly, that, as far as I can tell, that is the only guidance. And so then councils need to decide, because it's a have regard to point, whether they are picking up those minimum climate change scenarios. And there is some proposed wording in App 6, which is steering councils in that direction.
Yeah, okay. So where it says at paragraph 19, national climate change risk assessments must be prepared at intervals not exceeding 6 years. That would be setting out, such as in those bullet points above, what the sort of scenarios to be modelled are, or would. So there wouldn't be a national climate change risk assessment being prepared every 6 years, I would assume, under that national adaptation plan. That would be done at a regional level. I'm just trying to sort of get a bit of an understanding of what the council's doing versus what's done at a national level.
Yeah, so at a national level, at least every 6 years, there is the national climate change risk assessment. And I don't know, but I would expect that it includes assessment of risk that feeds into the types of things that are in the extract I've provided, because it's identifying the risk, and the risk is all to do with the risk of climate change. And then after each risk assessment occurs, there must then be a national adaptation plan, which flows from that risk assessment.
Right, okay. And yeah, and then with the council, I'm just thinking how that fits in with the sort of 10-yearly plan and policy statement cycle, and how councils would be keeping up with those 6-yearly national risk assessments. Is that potentially an issue?
It is potentially an issue. In the present context, that's the reason why we're resistant to cutting and pasting the actual numbers, because they may change. Well, they will change. But you're right, if we were to take time as starting today, you may have adaptation plan number 1, which uses whatever minimum scenario. Policy statement plans get made. They're not due for review until 10 years from today, but there could be a new risk. There could be a new risk assessment in 3 years if the science changes. And if that happens, it's not mandatory for councils to change policy statements and plans. It's a have regard to factor. So if that happens, it would be a question for individual councils whether to change any, or to make any consequential changes to their policy and planning documents. But in terms of how Mr. Kelly would no doubt correct me on this, but in terms of how Act 6 is written, it directs those applying Act 6 to consider, trying to put the right jargon, the shared socioeconomic pathway and representative concentration pathway, which for those in the know is a roadmap to look at the National Adaptation Plan, because that's where you find those things. So in some scenarios where you're applying Act 6, you will simply be looking at whatever the current numbers are. But in other scenarios where you're applying Act 6, it may be in the context we were just talking about, which is preparing a district or regional plan. I would hope, but it's way beyond what we can do here, that because of that potentially significant time difference, and the fact that those you can expect that guidance to change because the science is constantly evolving as measurement improves and there's more data. You would hope that district and regional plans don't simply cut and paste the relevant standard or numbers. They themselves refer to the source of those numbers to the extent they're directed and risk assessment occur. But, and I'm starting to spend too long on this, despite all of that, there will be things that are found in district and probably regional plans which are based on the climate change scenario as at today. For example, don't build a house here because the cliff's going to erode. And the science that lies behind that may change. And 5 years from today, you'll think, well, it's not just here, it's also here. Or you could think, well, actually, it turns out it's okay. And you would hope that will be the sort of thing that will trigger change, but that will be a decision for individual councils.
Yeah, okay. Because one of the things, and one of the questions I was just going to ask Andrew was, some of the policies are only relating to hazards identified in accordance with either NHP 1A or NHP 1, and in those situations, is there enough flexibility given we're in reasonably fast changing times at the moment, in relation to hazards? Yeah, that was sort of one thing I think that was raised in some of the evidence, and that I was interested in the response to that too. How nimble will will councils be responding to that if they're only really focused on areas that we've mapped?
I might defer to Mr. McKinnon on.
I'm sure. I think it was something that was discussed to some extent. We can come back to that. Okay. Discussing new. Yeah. Thank you. Thanks. Sir.
Your comment or submission rather at paragraph 9 under section 61(2)(e) of the Act, ORC must have regard to the National Action Plan 2022 and preparing the pORPS. Just looking at those words and just on your knowledge of the legal situation as to the timing of that sort of obligation, when does that become a statutory requirement of the regional council?
It is right now, and from memory, the date was November last year.
Right. So you say as a matter of section 61(2)(e) applies as and when the National Action Plan gets gazetted, as contrasted with whatever was in place when the plan was notified.
Yes. I would need to double check this, but I think that I'll need to check that, because there's a question in my mind as to whether the date we're talking about is the date the obligation to have regard to the National Adaptation Plan came into being, which is what I think it is, rather than the date the National Adaptation Plan came into being, because from memory, the National Adaptation Plan is long before 30 November last year. It's the requirement to have regard to it came into being at that point in time.
Yeah, could you give that some thought overnight and address us tomorrow on that?
Yes,
Thank you. Good. And just in a general sense, if you're looking at your paragraph 15 and policy 25 of the NZPCS and sub clause C, encourage redevelopment, so that's the NZCPS, encourage redevelopment or change in land use where that would reduce the risk of adverse effects from coastal hazards, including managed retreat. What do you say is the legal position in terms of section 10 and existing activities? What power is there by rule, or is there not, to require, as a matter of law, managed retreat?
I think that the authors, the view held by the authors of the coastal policy statement, I think, is evident in the policy and in the use of the word encourage. Because my view is that we have existing use rights in section 10 or one of the other provisions for your coastal home. In the resource management sense, you are able to be there without needing any consent, and notwithstanding what a plan may say about that. So there are real issues with doing more than encourage. And it's very hard to see how a council could introduce a rule that says an existing house, for example, and lawfully established, has section 10 rights, must go. So I don't think the tool for compelling that sort of managed retreat is to be found in the Resource Management Act.
I'm interested to hear that, because it certainly reflects my understanding of the legal situation, and I wondered whether I was overlooking something. But, there's nothing new that you're aware of that would enable.
No, I mean, I guess we could both be overlooking something, but I'm not aware of any tool in the Resource Management Act which would allow encouragement to move to compulsion.
Thank you. Just in paragraph 18, Mr. Anderson, that opening statement in the quotation that you've got, the interim guidance is non-statutory. That just seems to conflict with what immediately follows. However, from 30 November, councils will be required to have regard to this plan when making or changing regional policy statements.
Oh, so sorry, that's the context. The preceding paragraph, which I haven't quoted, refers to some guidelines that were more similar documents which have been prepared.
Right. Yeah. Okay. No, those are my questions. Thank you. And can I just make the general observation? I always find your submissions very easy to follow, and they just seem so logical until some other lawyer comes along and tells us, yeah, Mr. Anderson's true.
I had the benefit of reading yours, I guess.
Yeah, but no, I do. I found that particularly helpful as well, as I have the other submissions. Thank you.
Thank you. For Mr. McKinnon.
Morning, Mr. McLean.
Good morning. So I'm the reporting officer for the natural hazards and risk chapter, which, as Mr. Anderson has highlighted, includes two subchapters, the natural hazard chapter and the contaminated land chapter. I have an opening statement, which I will take you through and answer any questions. You've heard me speak before and has seen this first page before, so I intend to start on paragraph 7. In relation to natural hazards, in my view, the outstanding issues associated with the natural hazard chapter can largely be grouped into 4 main themes: the management of coastal hazards, infrastructure located in areas subject to natural hazards, amendments to APP 6, and kaitiaki decision making. There are some other discrete issues which have also been raised in evidence, such as monitoring natural hazard risk. In relation to the management of coastal hazards, some submitters seek clarity within the hazards chapter as to how coastal hazards are to be identified, managed, and in particular, which provisions of the hazards chapter apply to coastal hazards. Mr. Anderson has taken you through a little bit of this already, so maybe I can skip through some of these paragraphs. They are largely, well, they are supporting what Mr. Anderson has suggested in terms of which provisions apply to coastal hazards and which do not. Related to this theme, Ms. McIntyre on paragraph 12 for Kaitahu notes that coastal communities such as Karitane may be affected by a combination of hazards, for example, where river flooding and coastal storm surges come together. In such locations, she suggests there could be confusion about when the P3, P4 provisions apply or when the P10 approach is used. The hazards chapter requires that coastal hazards are to be identified in accordance with policy 24 of the NZCPS, and with respect to these coastal hazards, policy 10 will apply. When considering which processes are included within the identification of coastal hazards, I note that the NZCPS provides guidance on this as part of the guidance document that sits outside of the NZCPS, which states there are a number of potential sources of inundation in the coastal environment, including storm tides, spring tides, wave run-up, short-term fluctuations in mean sea level, river flooding, groundwater, sea level rise, and tsunami. Therefore, the combination of effects across those sources will need to be considered, including the combined and cumulative effects of sea, river stream catchment, and groundwater influences. So given this, I consider, in the context of the Karitane example, the identification of coastal hazards will ensure that the processes that affect coastal inundation will be taken into account when managing that coastal hazard. Turning to infrastructure located in areas subject to natural hazards, several submitters seek amendments to policy 3.1 to include an exclusion for nationally significant infrastructure that has a functional or operational need for its location. As set out in the Section 42A report, policy 3 relates to the risks associated with an activity. If a natural hazard risk is significant, the activity is to be avoided. If the activity is undertaken in an area of high natural hazard risk, but given the nature of the activity, the mitigation measures proposed, if the risks with the activity are not significant, then the avoid test does not apply. Given this, I disagree any amendments to that provision are required. Turning to APP 6, some submitters seek amendments to the chapter and the methodology in APP 6 so that it doesn't carry any legal weight or set unreasonably low thresholds for determining what significant natural hazard risk is. They consider natural hazard risk thresholds must be undertaken following a transparent community engagement process into the formulation of the risk. I consider the intent of APP 6 as twofold. First and foremost is a framework that will be used to inform future plan review processes where community input will ensure that the risk thresholds in district and regional plans are appropriate. Prior to that occurring, APP 6 provides a framework for undertaking our risk assessment within a resource consent process. When used in these contexts, I disagree any amendments are required. Within its original submission, the ORC Hazards team specifically sought amendments to the risk table, seeking either a greater requirement for a quantitative risk assessment or additional scenarios be considered significant rather than tolerable. Following pre-hearing conferencing, an amendment was made to APP 6 that included an additional requirement to undertake a quantitative risk assessment. To highlight visually when a quantitative risk assessment is required, I suggest the additional amendment is made to the risk table to include hatching where that quantitative risk is required, and that's shown in the risk table below paragraph 21. Following a meeting with the hazards team, they confirmed that the combination of the change in the consequence table amendments to the quantitative risk trigger and the additional hatching resolves their concerns. And I know John Luke's going to speak to the hearing, so I don't want to speak for him. That's just feedback we got at the meeting. Paragraph 23 just supports some suggested amendments that Mr. Kelly from GNS will speak to you about, so I'll skip over that. At paragraph 24, kaitiaki decision making, Ms. McIntyre for Kaitahu has sought an amendment to the notified version of P10. She notes that the intent of the policy was to provide for whakatera taka in respect to decision making on Māori land susceptible to natural hazards. Within my section 42A report, I recommended that the policy be deleted, as I considered there were already pathways for community stakeholders and partners to be included in the risk assessment. On reflection, I agree that a redrafted version of P10 would support methods 2 and 5 in the hazards chapter and better align with the direction in the mana whenua chapter and the HCV chapter. Following several discussions with Ms. McIntyre, Ms. Bathgate and Ms. Stevens, I'm now recommending a two-staged approach to the policy, which is set out below. This recommended drafting aligns with the management approaches taken for native reserves and Māori land in the mana whenua chapter and the management of Waikitupuna in the historic and cultural values chapter. So I'm suggesting an inclusion of the following policy as set out there. Paragraph 27 sets out why I think there's scope for the amendment. And finally, on paragraph 28, Mr. Place, the QLDC, has correctly highlighted that within my section 42A report, I recommended the inclusion of a new method as set out below paragraph 29. However, this change was never incorporated into the section 42A version of the RPS. That was an omission, and I still support the suggested amendment. Moving to contaminated land. In my view, the outstanding issues associated with the chapter largely relate to 4 key provisions. Policy 14, managing contaminated land. Policy 15, new contaminated land. Policy 18, waste facilities and services, and a method M8, prioritising action plans. In relation to policy 14, this policy aims to manage already contaminated land or potentially contaminated land. Mr. Anderson has set out some of the criticisms of this policy, and I retain the view as set out in my section 42A report. In relation to policy 15, this relates to the avoidance of new contaminated land, and again, Mr. Anderson has set out some of the criticisms of those policies. At paragraph 36, I largely retain the view that the drafting of the policy in the section 42A version is appropriate. However, I do support a minor amendment suggested by Kaitahu that replaces mana whenua with Kaitahu for consistency throughout the plan. Paragraph 37, the Kaitahu submission and evidence of Ms. McIntyre sought amendments to policy 18 to provide greater clarity as to the adverse effects that must be considered. Within paragraph 533 of my 42A report, I largely supported the submission from Kaitahu. I won't read that out. However, no changes of this nature were included in the track change version of the chapter. On reflection, I consider the architecture of the RPS as such that all relevant provisions of the document are to be read together and considered on their merits. Given this, I consider the relevant environmental and cultural protection provided by other policies in the RPS will be considered when applying this policy. So I disagree any amendment is required to that policy. And finally, following a pre-hearing meeting, recommended an additional limb be added to P14 and a new method be added to the contaminated land chapter related to the identification and management of closed landfills and contaminated land at risk from the effects of climate change. In response to a submission from Kaitahu, Ms. McIntyre for Kaitahu provided further evidence on the methods, noting that a reference to the prioritisation of sites at greatest risk has not been incorporated into the method. I agree it should be incorporated into the method, and as such, I'm suggesting an additional change to that method as set out below paragraph 40. That's a high level once over of the two chapters.
Thank you. Maybe I'll start your supplementary, Andrew, just paragraph 17 around this issue of infrastructure located in areas with subject to high risk, significant risk. And this is more for my clarification of how this might work if we put it into realistic terms. Kaikoura as an example, and outside of Otago, I'm struggling to think of an Otago one, maybe be Nevis Bluff or something, where you have no option but to put infrastructure through an area like that. What would this policy do for that if it wasn't existing now? You wouldn't be able to go through there at all, so you wouldn't be able to service that area.
No, so I think that that's kind of the way I interpret it, and I hope this is the way it's reflected, is that the intention is that where the natural hazard risk is significant, that activity is avoided. So, for example, to get to the point of what is the natural hazard risk, we start by, and maybe I can go to APP6 as a bit of a guide. We start by identifying what is the likelihood of an event occurring, then what are the consequences of that event occurring. So if you're talking about, say, Kaikoura and a new road, or Kaikoura and a new power line, or whatever it might be servicing any of those areas, it's important to look at what the consequences of those are in terms of the risk. And these are largely related to risk to life and risk to buildings and things like that. So if you were to be putting a new infrastructure through some of those places, even if there was a high likelihood of something event occurring, so it's a really high risk area, I don't think that you can get to the point where the consequences would create risk to life or risk to buildings, because it's infrastructure. It's not a new subdivision, it's not a new hospital, it's not somewhere where people live, it's infrastructure. So my reading of that would be that you would have quite a low consequence, even if the likelihood of an event occurring was high. And so you would probably be somewhere in the insignificant, minor, moderate in terms of consequence, which puts you in either a acceptable or tolerable risk category.
Yeah.
So even if you're in the highest risk, the riskiest part of the district, you still need to understand what are the consequences of an event occurring for that to then create a significant risk.
Yeah.
And those consequences are largely related to risk to life, risk to buildings. And
I guess a road or a railway's got people using it now. I guess because and I can't see where I've written it down, but what occurred to me, it was, and I think it's been raised by some submitters, is it's avoiding the activity as opposed to avoiding the risk, if you like, through design.
yeah,
So some of those things can design to avoid that risk.
yeah. And I think it was Ainsley for Transparels, or one of the submitters had talked about that. Again, in my view, the consequences associated with the risk include the mitigation measures you're proposing.
Yeah.
So, for example,
that's
right. So if you are building a new power line, building a new road, you're building it knowing that those risks are around, and you're probably going to do a lot to mitigate that potential risk. all of that gets factored into that consequence. So that's why I've known it's come from quite a few infrastructure providers, highlighting that this could have an impact on how they do their business. It's still my view that because of the way this table works, all of that mitigation gets included in that consequence assessment to determine whether it is going to have a high risk or not, or tolerable or significant risk or not. So that, I guess that's the point of that consequence assessment.
Yeah, no, that's good. Thank you. Just sort of related to it, there's some of the phrasing in the throughout the documents. I was slightly confused about how things have been worded. Well, for example, will increase the risk from the natural hazard. I take that to mean that you don't increase the actual effects from the hazard on by putting new things in there. Some other people interpret that sort of differently, meaning the activity itself is magnified the actual occurrence almost of the natural hazard. Ms. Taylor's here, actually, she made a comment in relation to policy 3 that understood the intent to prevent occurrence of the significant natural hazard resulting from an activity. That's not how I understand that phrase.
No, so I guess that the way I interpret that is that it's it's not that the risk that the activity is going to increase the occurrence of the natural hazard. It's the effects of the natural hazard and how that relates to the new activity, for example.
There is the two scenarios, isn't it? Because the activity itself could actually increase flooding, is the classic. Could actually increase the effects of the natural hazard elsewhere. And quite often works put in place to actually deal with that, do that. So it's just weird that those phrases are used. I haven't got them in front of me, but some clarification maybe is required around those. There was a question. If is raised, and it's page 18 in your analysis.
Is that, sorry, the 42A report?
Yeah, 42A report, sorry. Just some clarification around the context and categories of risk defined, and they refer to Standards New Zealand. Why would you not use the same terms as Standards New Zealand? And is that standard the same as the A/NZ IEC? And it's very long, but that 2020 standard that's referred to elsewhere. There seems to be a lot of different standards referred to. I'm not quite sure where they all come from.
Yeah, so at my paragraph 73, so below that,
You say that they mean the same things.
Basically, except for the fact that in section 6H, or I think it's H of the RMA, it talks about, so the three categories being acceptable, tolerable, and intolerable, and the NZ standards, and the APP6 using acceptable, tolerable, and significant. The significant, as opposed to intolerable, was put in there because section 6H, 6 and 6H, talks about significant natural hazard risk. So I saw these three categories as being basically the same, with intolerable replaced by significant, because that's what the RMA uses. So that was the only rationale. I know other plans, and Scott might be able to correct me, use these three labels, but I guess the question in my mind is, what then is the difference between an intolerable risk and a significant risk in terms of the RMA? And given we have the RMA with using the term significant risk, to my mind, it seemed it was more logical to use that term that's in the RMA as the highest threshold of risk.
Thank you. Just in relation to, I think it's more of a, it's the existing use rights, and you referred to a case in the Bay of Plenty, but you didn't actually tell us what that case said about situation. Actually, your page 80, paragraph 345 and down to 347. You made a kind of disagreement measure existing use rights under section 10, but the RMA is the only method of implementing risk reduction measures is set out in P4. I think probably the comment most people make that you can't actually manage it or implement risk reduction measures under section 10. I think that's what the chair raised. So I'm just interested in what that case said, and whether you have a copy of that.
We're in that, which case? Sorry, I'm
So you see in your 345.
Oh, sorry, I'm on page of it on 345. Yes.
And that's actually the GNS report talks about the submitter saying it's legally not possible under section 10 to do it. They're going to say, well, it's strictly true, and then refers to that case, and you've relied on that. So I'm just wondering if you've got a copy of that and what it actually says.
Yeah. The short answer is no, I don't have a copy of that case, but
So
it's certainly something
Scott
that,
will have that.
yeah, and something that we'll no doubt need to consider and provide some direction on as for our advice on in the reply report, maybe. Certainly something we'll note.
I must admit, I have read that reference in paragraph 345 to the word case. I've read that as being a situation rather than a legal case as such.
Yeah, I wondered what case meant as well, but we talked about existing use rights. So
yeah, that's taken from the chair. There might be something, I mean, firstly we can come back to, but also maybe Scott might be able to answer as that's part of the GNS technical letter.
Yeah.
Scott might be able to answer the question. I can't find it. He used the word agnostic in one of his reports. How does that relate to natural hazard? It's on page 105, your paragraph 439. It's probably a question for Scott. And then the second last paragraph there says, the past consequences are inappropriate when assessing current risk. And I thought they were always at the forefront of people's mind when you're assessing current risk, what's happened in the past.
Yeah, I might have to defer to
So that
Scott on
question,
that one.
Scott,
Well. Yeah.
Probably also for Scott is where the consequence table came from. Or, what is that taken out of? Is that a standard approach for?
So that was taken out of a paper, again, drafted by GNS that provides a bit of it was called a risk-based assessment to natural hazard management or something along those lines. And it had this 4-step process in there about how you identify and manage natural hazard risk. And so that was one of the examples included within that technical document.
On that, there's that risk table that you're suggesting an amendment to,
Yes.
in relation to Jean-Luc's.
Yes.
I'm also assuming that will address QLDC's concerns around that. That's a very similar issue they raised, wasn't it?
Yeah, I don't want to speak for Luke in terms of whether that will certainly he was suggesting that more quantitative assessment needs to be done, or the trigger for when that is done needs to be brought forward so that there are more of those assessments done. But whether that would resolve all his concerns, yeah, I'm not sure. It certainly is going in that direction.
Is that Jean-Luc's concerns or?
Sorry, that was QLDC's concerns.
Yeah. I'll leave the contaminated lands. We had a discussion about that. Look, that just leaves me with one further question, really. Ms. McIntyre's here because I was going to ask her this, but now you've accepted this policy. The enabling Manawhenua to lead approaches around the management of natural hazards that affect various parcels of area. In principle, fine. The issue here, though, is slightly different to, and if you think of natural hazards in terms of a spatial context, and you have, say, a floodplain or something, you have one bit of land in the middle of it that's been treated differently to everything else. Is that sort of inconsistent approach, potentially inconsistent approach, wise? And what are the implications of that? Have you thought that through and what the implications of that might be?
Yes, I guess, yeah, it is a good question, and it's certainly something that that we've considered in terms of, I guess, for this example, and it's still a bit of a live question in my mind about enabling Manawhenua to take the lead on particular natural hazards. So usually what happens in this context is that, say, the ORC, who has a lot of the technical knowledge and understanding of flood risk or fault risk or whatever, go out and do the mapping exercise, and arguably that's ORC taking the lead in that sense in terms of the technical information. And then what this was trying to step through is, once you have that technical information, how you manage that risk on native reserves may be different than, or how that conversation starts may be different if it's on Māori land or native title versus other parcels. So that's the way I'd interpret it in terms of not necessarily some parcels have a different flood assessment done because Ngāi Tahu or Kaitahu are taking the lead on that. It's more so when you get to that, once you have the information, how those management approaches are led will be led by Manawhenua.
So it's more of a process thing rather than.
Yeah, so
surely the outcome could be different too, because as I said before, there's two ways of looking at the effects of natural hazards. So you can have activities that will exacerbate the problem. Flooding is the good one, letting people do things on their land that suddenly impact on other pieces of land that you never had an issue before.
Yeah.
And if you took this approach and that happened, confined to the pocket within floodplain, you might have that. I assume that will be worked through. That's just having two different processes. For an issue like that, I just wonder about the practical implications and the ramifications of that.
Yeah, it is. It's a good point you highlight. I don't know in practice whether it would have. I think the process would be different in terms of how those management options are considered and engaged with. Whether there's two completely separate outcomes at the end of it, I guess is just because Manawhenua are leading that doesn't mean they'll come to a different result to the rest of that catchment or whatever. It just means that they've had the ability to lead on their parts of on their properties.
Yeah, it does open the option up, I guess. So I'm sure Sandra was recently on that.
And I don't want to speak for Sandra as well. So this is something that we've been working on the background for a little while now. I guess the original policy started quite geographically really broad and said kind of Kaitahu are going to be able to contribute to decision making across a range of geographic areas.
Yeah.
And then that was criticised by submitters. So we've come back to refining firstly what is really important to Kaitahu and mana whenua, which is firstly effects on native reserves and Māori land, which geographically is a lot smaller than where we started. And then secondly, including Kaitahu decision making on hazards affecting Waihi Tupuna areas. So we've gone from quite a broad scale with quite a general policy to quite a small geographic area, but with quite a lot more direction as to how that is done. And so I guess that's kind of the...
I don't think B really raises that issue, because that just means Kaitahu's got to be involved in how you deal with that. And the other one's probably has potential to lead to different outcomes in different lands within a hazard catch review. We'll leave that.
Yeah, I guess one of the other things we've been playing with, and Sandra will speak to this, and I'm sure, as to why we didn't go with it, but another version was enable or partner with mana whenua to da rather than take the lead. So it's, again, there's, I guess, a range of iterations we've been talking about here. But yeah, you're right. It's a good point you raise as to whether that would create sort of two outcomes and whether that's what we're trying to do.
Yeah, okay, thank you. The only other thing I was just to highlight your suggested changes to a PP6. We've removed reference to the first part of the posting principle in step 4, which is on page 119 of your section 42, but over the page on 120, we still an inclusion there in the second last paragraph. I'm not sure if that's actually part of the APP6. Well, it is, yeah. Hasn't been removed, reference, yeah. So I'm assuming that's just a mistake. Yeah. I don't know if that makes any difference to the rest of the text there.
Yeah, I see what you're raising.
You might just have to
that might be something I certainly reconsider as part of the report.
Okay, thank you for that.
Okay, thank you. Sorry.
Yeah, it's. I'll go to NH 11. Your paragraph 24, 25, 26, 27. I've got a couple of questions. The first question is, you've come back with a recommended rewording. Now, has that rewording been agreed? I mean, you've run it past Kaitahu and...
That's right, yeah. So it's been emails back and forth between Kaitahu, myself, and Ngāi yeah. And a few wee hui at the planning conference between breaks. Yeah.
Right. Okay, and I'm curious, and this probably demonstrates my ignorance here really, but the notified version of P11 started off with recognise and provide for. And I probably need a smart lawyer or planner to explain to me what provide for means and why it's not in the redrafted version that you've provided. It kind of means something to me, but I'm not quite sure whether I've grasped the right end of the stick.
Yeah, so I guess it's recognising and providing for the role of Kaitahu as kaitiaki over Waihi Tupuna, Māori reserves, freehold land. so I guess the provision for kaitiaki over particular areas, and I guess the bit which we are kind of moving to, or the bigger change in this into my mind was that it says by involving mana whenua in decision making and management processes. So it's we're doing something and you can be involved basically. And where we're getting to now is that we're enabling mana whenua led approaches to certain
you use
things.
the word enabling.
Yeah. So it's
On the reserve lands and Murray land bit,
mhm,
but on the Waihi Tupuna, you've used the word including.
mhm,
I think I can understand what they mean, and there's a nuance difference. Well, it's more than just nuance, it's a quite clear difference. But it wasn't so much that, it's just the words recognize and provide for. I mean, that to me is not only you recognize, but you then
mhm,
have systems and processes in place to ensure that it happens.
mhm.
To me, recognize just said, okay, we see it there. So what? Almost.
Yeah.
That's the point I'm trying to make.
No, I see where you're going in terms of what it just says recognized now. I don't think that was a conscious decision to remove provide for. I think we were looking more at the buy and how you do that, and kind of had overlooked the first kind of action.
Because it actually cuts to a much wider issue here around, you've used the title Kaitahu Raka Tika Taka.
Mhm,
The original notified version is Kaitiaki decision making.
mhm,
Two quite different things.
mhm,
I actually like the revised wording, but that brings with it a raft of other things that I think need to be, need to be included in the sort of wider thinking. I mean, there's nowhere else in the plan at the moment that highlights Kaitahu Raka Tikatanga in quite the same way. It does in various other things, but to me, that's quite a statement.
mhm,
That it's a really clear statement of saying, yeah, Kaitahu's place in the world is actually real,
mhm,
enabling them to manage or lead the management process around Māori land is kind of, it's gone that extra step further. And I did, when I first read your draft here, hesitate a bit when I saw B, including Kaitahu.
mhm,
But then I looked at it's around the values of Waihi Tupuna. Now, Waihi Tupuna are Waihi Tupuna, but they're also other places, they're places that everybody deals with. So I can understand the slight difference, but I just...
Yeah, I might let Sandra speak to some of the discussion on Lakatirataka, because this drafting has been heavily influenced by so I probably don't, probably a little bit out of place for me. I'm supporting where she got to, but yeah, those questions might be better directed at Sandra. But yeah, certainly that provide for is something that we can.
I mean, I'm pretty much going to ask some questions anyway, that's coming. And the other bit that I was unclear about, but I wondered whether I could get a further comment from you on, is the CLP18. Where Kaitahu had sought greater clarity, I suppose, on adverse effects that must be considered. Now you've said no. I don't quite understand your explanation for not including it.
Yeah. So this policy is about providing for the development of facilities, services, storage, recovery, treatment, wastewater disposal. And what I was thinking with that paragraph, so below paragraph 38 in my opening statement, I had largely said, yeah, I understand where you're coming from. This policy needs an addition to say, and also consider all of the other environmental and cultural protections that are within the RPS. And I was thinking something along the lines of the aquaculture policy in the coastal chapter, which says enable aquaculture while also considering all of the other environmental policies that relate to the coastal chapter. This I see as sort of a similar type policy, which is enabling something while also having some things that you need to consider. When I went back and looked at what that drafting could look like, I guess I hesitated because, for example, if you were to develop a facility or service like this in an outstanding landscape or in a Waihi Tupuna area or in an SNA, the Waihi Tupuna provision or the SNA provision or the landscape provision would also apply. So you wouldn't look at this policy and say, oh, this is how we manage waste facilities and services in the absence of where that's located. So that's why that's I guess the rationale in my paragraph 39 is that the architecture of the plan is such that you look at all the provisions that apply at the same time. So when you're looking at this policy, there will be other policies that say avoid certain things, avoid having cultural effects, avoid having effects on SNAs. And so that's why I didn't include an additional limb, which would basically say the same thing. Consider all the other environmental and cultural policies with the plan.
And this is one of the things that you talk about in your recent conversation.
No, this is not something, Sandra hasn't seen this. So that's, yeah, that's something that we can discuss.
All right. Right, thanks very much.
Yeah, thanks very much. First of all, I was just quite keen to explore with you what, I suppose, how consent applications for new activities would be managed prior to the identification under P1 being undertaken, or potentially P1A. Because I suppose I'm seeing policy one sort of requiring identification of areas. And then we've got P2 that's saying for those areas, saying is assess natural hazard risks under a range of scenarios, etc. And then we've got new activities under P3, which is referring back to P2. So it's referring to those risk assessments, which I think are under M2, are they? And then for existing activities, those are going back to P1. And I suppose I'm just kind of keen to know, and I take the point, I think it was Annette Wolf who was indicating there was no timeline under method, it was method 2, for the risk table and for that method 2.1 step to be undertaken. So given there's no timetable for that identification, I'm just wondering, a lot of the sort of policies around new activities and existing activities are reliant back on those identification. How does that, what's going to, I suppose, happen, and what's the guidance going to be until that work is done?
Yeah. So I guess, and something I think it was QLDC and Luke raised in his evidence on, he felt that P2 and P3 kind of assumed you knew everything about all the hazard risks, because you're saying, because my addition starts within areas identified in P1 as being subject to natural hazard risk, and his point was you don't always know where that is.
Yeah.
And
that was another question I had around, you know, given things are changing quite a lot, and I think, I suppose, Christchurch earthquakes taught us that, you know, we were pretty good around the liquefaction, but we weren't so good around the rockfall risk in terms of the assessments. Yeah, how's that managed as well? We actually don't get things quite quite
Yes,
viable. We haven't considered certain scenarios, those sorts of things.
Yes, I guess the way I think P1 would be given effect to is it's in my view, it's not a static policy. So P1 is about using the best information you have to identify where natural hazards may affect people and communities by assessing certain things. This is largely a policy that is going to, or represents what the OIC hazard team does already. So they go out and they look at different areas where they know there's natural hazard risk and continually update a database that's available online, which has all of their information in it. So my understanding, or the way I consider this policy would be applied, is that the same thing would continue. So there's a top of the lake natural hazard assessment program going on up in Glenorchy and around some of the Queenstown Lake areas and stuff, which is driven by the IC hazard team. They're continuing looking at where they need to update the natural hazard information and then including that in a database. So this policy is not just once the district plan is written, these are where the hazard overlays are. The hazards team's always doing that updating as budgets allow. Then P2 kicks in where you know that there is a natural hazard, because I guess if you don't know there's a natural hazard, then you're probably not looking to do a natural hazard assessment. So that's kind of the way I see them, is that it's not that P1 is not fixed, it continually evolves.
So at any time that information is available to the best of OIC's knowledge
That's
for
right.
anybody to come along and access.
That's right.
Yeah.
So maybe I didn't answer your first question very well because I kind of jumped to that part of your question. And I think your first question was more about, from a resource consent perspective, how does APP6 work in that context prior to a plan change occurring, which would give effect to this sort of stuff. And that's a bit of a trickier question, I think, in terms of a new application being lodged in a particular area. We've tried to, as I mentioned in the opening, develop APP6 so that it can be used in a resource consent process prior to a plan change being undertaken, which has all of this risk assessment built into it. And so there is a method, there's two methods, M37 and M47 in the hazards chapter, which tries to kind of step out how that would occur in a resource consent process. So require natural hazard risk assessment commensurate with the level of risk from the proposed activity is undertaken where an activity requires a plan change or resource consent to the use of land in areas subject to natural hazard where the application is lodged prior to natural hazard risk assessment being completed. And you go through the risk assessment in APP6 to determine that. So I guess that method in M4 is the method that helps direct how the resource consent process might occur prior to a plan change being undertaken.
Yeah, but I suppose I see this sort of tension, given with climate change, everything's kind of in a bit of a state of flux between, and I take your point around P1 that the council's constantly managing and updating these things, but I mean, I suppose maybe I was thrown off by M38, which refers in there to once a natural hazard risk assessment required by M21 has been completed, included in the relevant regional plan and made operative. So I was kind of thinking those things are sort of locked in stone for a period and need to go through a plan change again. So you're sort of losing that ability to respond and be flexible in relation to these things. And I suppose it's balancing the need for kind of certainty but making sure that decisions are made based on the appropriate information available. That's up to date and responsive to changing times.
So that method 8, if I remember, came through submission from DCC or QRDC or Portago. And I guess the concern was that, for example, in the DCC context, the 2GP has largely adopted a lot of these principles and has gone through a process where it's done sort of a risk assessment, and then it's got some activity statuses at the end of it, which reflect that risk-based approach. And so in that context, you wouldn't want parties to have to go back through the whole risk assessment when you've kind of done that at the district level. So that was what I was trying to get at.
I mean, is there is ORC and the district council, do they have a sort of a working group around hazards? Are they working really closely together on all this kind of stuff? Or
so there's a natural, so Jean-Luc is the team leader for the natural hazards section, I guess. I'm not sure what his exact title, but so they lead the development of the technical work for where that starts, I guess, biting in terms of district plans and things. They go out for community consultation, and he might be able to speak to the head of the lake process that's going on at the moment in terms of them speaking to, say, the Glenorchy community and a few others about what the risks are and what their steps are to then manage or retreat from that risk. So he might be better placed, and he's attending the second day, so tomorrow, to discuss some of that.
Another question I had was just in relation to use of the term tolerable in the plan, and I suppose I went through and read it before I looked at Appendix 6, and I thought tolerable, that's quite subjective. And this is probably a drafting thing, but I wondered if there does need to be a definition in there that it's not through the policies and objectives, it's not specifically referring through to the appendix and the use of the appendix to determine what tolerable is. I mean, is that something you considered?
Yeah, it was, and I think that it was really tricky to determine in a definition, because it is so reliant on what the likelihood and consequences are to determine what that tolerability is. Maybe this is a helpful time to kind of so most of the provisions in the chapter are largely what's in the 2019 version in terms of avoiding significant adverse effects and managing tolerable effects and accepting acceptable risks. The criticism was that the policy suite was there, but there was nothing to determine what acceptable, tolerable, or significant was. And so I guess the big change between the 19 version and this version is that APP6 has tried to step through how you would go about undertaking that assessment, because it seems just the definition seemed quite tricky, and there wasn't obvious definitions that could be included, and so that's why we went down the approach of this appendix, was to try and provide guidance as to how you would consider what those are, and usually that requires community consultation to determine, because it might be different for different communities what that tolerance is, for example. So it wasn't as simple as just being able to keep the 19 version policies and include some definition for what those things were, because it is, as you say, quite subjective and might change throughout the district or the region.
Yeah, so it wouldn't be just as simple as saying not exceed a tolerable level as determined by APP6.
Well, I see what you mean. Yeah, that might be that reference back to APP6 might be helpful. Yeah, I see what you mean.
If this is sort of a reference or even a definition that links through to as determined by APP6, at least I'm saying it's tied in. It's sort of I suppose some places are referring through to APP6, and in some instances it's just referring to the word tolerable. And I mean, maybe, I suppose someone could put a good argument forward that APP6 is how you determine it's tolerable, and that should be reasonably clear in the plan, but you never know how these things get argued, I suppose. Just check, Alan's covered off some of the other things I had. All the technical questions. Yeah, but I suppose the only other sort of thing I was looking at, I mean, do you think Well, are there areas where managed retreat may be necessary? I mean, I suppose you look at sort of the northern areas on the west coast, other areas on the west coast, some parts of Canterbury. I'm not as familiar with some of the areas around here, but is managed retreat something that is likely to need to be seriously looked at?
Mhm.
And if so, do you think that the provisions in here are kind of going far enough or are bold enough to be dealing with some of the climate change impacts that we're going to need to look at? There's one question I had in relation to APP6, which is probably more for Mr. Kelly, about to what extent is that built into APP6 as well?
Yeah, so in terms of the managed retreat, I guess the framework in this chapter, so P4 in terms of existing activities, has in subcourse 3 managing existing activities where significant risk to people. So managing reduce existing activities by managing existing activities within areas of significant risk to people and community. So the language is not managed retreat in here, and then I guess following
so
through.
You're thinking managing activities could be moving activities potentially.
Yeah, and so then M2 and the M2.3 says investigate options for reducing the level of natural hazard risk with areas of existing development to a tolerable or lower level, including by managing existing use rights under sections 10 and 11. So it's about investigating the options to manage existing use rights. So it's not necessarily going as far as saying managed retreat is going to be undertaken here and here. It has some levers in here for local authorities to work collaboratively to investigate options to do that, but it doesn't go as far as requiring it in certain areas.
Yeah, okay. Yeah. That's good. I think that's real for me. Thanks.
I've got a lot to ask you about, but just touching on that last issue, there seem to be differing messages on my looking at the chapter in relation to section 10 or existing use issues and managed retreat. And it's a terrible way of working, but how about we work backwards? And if we start with the marked all these, but I'm not sure that I have. If we start with the references to here we go. Sorry, I looked at the wrong document. That's why I can't find it. Here we go. If we start with the explanation at page, so turn to your page 85, so quickest way of going, probably at the second paragraph, which paragraph 364, you've quoted the provisions require that the same risk-based approach is taken when considering the management of existing development. And the wording used is by ensuring that the risk associated with existing development is tolerable or lower. So then if you look at paragraph 381, where you set out the anticipated environmental result at number 4, where existing development is subject to risk from natural hazards, the level of risk is reduced to a tolerable level. And when you then look at your paragraph 347, you'd made a statement that I'd underlined, and the second and third lines, fourth lines. I disagree with management of existing use rights under section 10 of the RMA is the only method of implementing risk reduction measures set out within HNZ P4. And P4 doesn't adopts a much if you like, more realistic appreciation of the legal position, because it talks about in P4 in number 3, subclause 3, managing existing activities within areas of significant risk in relation to natural hazards to people, communities, and properties. So it just uses the terminology of managing. You then look at in the provision M2 that you just referred to, at subclause 3, investigate options for reducing by managing existing use rights. And then M4, though, gets back to this, and I accept that you've recommended the amendment, but in paragraph subclause 2, the original wording was to require implementation of natural hazard risk reduction measures. You recommended changing that to just implement natural hazard risk reduction measures, including to existing activities in accordance with P4. And there's been some criticism from submitters. Does that really make any difference? Changing require implementation of to just implement. And what I'm really not seeing, and it was why I raised the question with Mr. Anderson about existing use activities, because there seems to be a flavour in those AER comments and the explanation that you can require it, but when you go back to the policy, when you go to the methods, it looks like you can't. You're acknowledging the provisions acknowledge that you can't require it, but then M4 implement these natural hazard risk reduction measures against the background where counsel for ORC is acknowledging today that he's unaware of, and I'm certainly unaware of, any mandatory statutory way of reducing the Section 10 and Section 20A entitlements for existing use activities. Do you think that these provisions that I've just run through with you paint a clear enough picture that it's got to be an encouragement approach rather than a mandatory approach? Now, I'm not saying that that's good. In a personal sense, I wonder whether we are missing the boat really in relation to climate change. But there seems to be a statutory lacuna, and it's really a question of should this policy statement make that lacuna clear rather than leaving it a bit muddy as it appears to be now.
Yeah, I think there's two things in there. The first one is the intention of the plan is not to require, as you say, for existing use rights to require them to be managed or removed. The intention is that it's always about encouraging or considering or working collaboratively too. The second part of that method that you were discussing, which I suggested an amendment to, which was M4.2, was about natural hazard risk reduction measures, including existing activities. So I kind of see potentially there's the mandatory retreat or the removal of the existing use rights as one way to manage the existing risk. But P4 has a few other things like encouraging activities to reduce vulnerability, encouraging design, relocating unacceptable risks. So I guess I'm saying that the one arm of managing existing risk is Section 10 and existing use rights, and we're not saying you have to do that, but there are other things in that risk reduction spectrum that could be considered, such as reducing vulnerability and other things like that. So I don't see. I see them as slightly two slightly different parts of the same reduction of risk package.
I hear what you say. I just wonder when you come to the closings, just reconsider that word and see whether you can work out a wording that conveys
Yeah.
what you're trying
Yeah.
to say now.
Yeah.
Thank you. Can we just turn to Appendix 6? And the very point that Sullivan was discussing with you. I was reading the evidence and reading the criticism, particularly from QLDC, etc., and just trying to reflect on how on earth could you work out where acceptable, tolerable, or significant, where did that come from? And because, and I just wanted to ask you, have I got it wrong? But the only reference that I've been able to find is in step 3. So at your report, page 287, step 3, where using the information within steps 1 and 2 of that, complete table 8 for each of the hazard scenarios considered, which seems to me, in reality, consider tables 1 and 2, and well, not tables 6, 7, and 8.
Yeah.
And identify if the risk for each of the scenarios is acceptable, tolerable, or significant.
Mhm.
That seems to me the only place where it's really identified. 6.
Mhm.
Am I right about that?
That's right. And
And the difficulty with that I've just got with that is that when you look at each of those tables, 6, 7, and 8, are using different terminology. I appreciate some looking at return frequency, some or likelihood at a scale, others table 7 is looking at the consequence of that, and then table 8 is looking at really a combination of trying to get a risk table.
Mhm.
But they all use different terminology, ranging from the table 7, catastrophic, major, moderate, minor, insignificant.
Mhm.
So it becomes the reason why I suspect you're unable to really give a quick answer to Bianca about how do you define it,
Mhm.
is because it can't be defined, can it? It really, the word tolerable or significant or acceptable
Mhm.
requires somebody with the knowledge and the ability to apply tables 6, 7, and 8 to be able to come up with a conclusion.
That's right. Yeah.
Well, I must admit, having been hopeless at maths throughout, that I really struggled when I was looking at requirements of trying to assess if things to 10 to the power of 1 or 4, 3,
Mhm.
4, or 5.
It's been a learning
Those
experience
are
for me
just
too.
noughts, aren't they? Aren't they just noughts? Why?
Yes. Yeah.
Why on earth, for the lay person, wouldn't you just use noughts rather than 10 to the power of 4 or 5? That's a lighthearted question, but it's a bit serious because
Mhm.
you really do want documents to be able to be read by people.
Mhm. Yeah, it's, as I say, it is. APP6 has been a bit of an education for me too, as a planner who has had to learn a lot about this. And I guess even going through some of the environment court or cases where you are in that risk assessment, we are trying to get a development through, it does end up being really technical as to what is the risk to life for this or not. And I know in the Christchurch Sea Plan, for example, for the rockfall risk, it does get into this sort of detail about when it's 10 to the power of 6, is this going to be the risk to life is unacceptable or not? So I completely take your point that it is very technical. But when you're trying to avoid a particular activity based on its natural hazard risk, you need to be able to draw a line or help draw a line or lines to determine when a risk is no longer acceptable or significant. And so it seems that's kind of the reality of risk assessments, is that it does get into that kind of detail before you can say no, essentially. So yeah.
Okay. Final question, just as you were having your discussions with Commissioner Kirikiri about your rewording at paragraph 26, I was just contemplating is if you look at A, enabling Mana Whenua to lead approaches to the management of natural hazards, is that really what's being managed, or is it management of risks arising from natural hazards?
Yeah, I think it's the latter.
Right.
Yeah,
Yeah. Okay. All right. No, look, thank you very much. And the challenge that you talked about as a planner is nothing compared to the challenge for an older lawyer trying to cope with appendix six. Thank you. We'll have a break for morning tea. So for quarter of an hour. Thank you. It's for Mr. Kelly.
Well, it's being handed out. I can answer the question about the 30
Oh, yes.
member date if that's helpful. 2-minute answer. So 2-minute answer, what was in front of me. Section 61 2E came into force on 30 November 2022 is the answer. And the references are section 17 of the Resource Management Amendment Act 2020 and section 2 of the Resource Management Amendment Act 2020 Commencement Order 2021.
Okay, thank you. Good morning, Mr. Kelly.
Kia ora, good morning.
So we're in your hands. Thank you.
Thank you. Prepared an opening statement, which I understand has been distributed to you all. I will start at paragraph 2. My qualifications.
We can jump further than that if you would. If we can take you over to paragraph 6 and if you start there.
Paragraph 6. Yes. So here I respond to the submission and of Queenstown Lakes District Council and the evidence of Mr. Luke Place around the inclusion of representative concentration pathways in step 1 of APP 6. The section 42A report of Mr. McClenaghan recommends that inclusion. And Mr. Place, on behalf of QLDC, considers that the amended text should be more directive in regard to which representative concentration pathway scenario should be considered. Paragraphs 8, 9, and 10 set out what representative concentration pathways are. They were developed for the Intergovernmental Panel on Climate Change's 5th assessment report. And shared socioeconomic pathways with sort of the evolution of those, and were released as part of their 6th assessment report. At paragraph 9, as Mr. Anderson has raised, the National Climate Change Risk Assessment considers 2 of the representative concentration pathways, being 4.5 and 8.5. And at paragraphs 9.1 and 9.2, I describe what those are. At paragraph 10, I talk about what shared socioeconomic pathways are, where they take the representative.
Can I just take you back? And I think for this panel, it would be helpful actually if you did take us through and read through those 9.1, etc.
Yep, yeah. So representative concentration pathway 8.5 is a high concentration pathway characterized by increasing greenhouse gas emissions driven by a lack of policy changes to reduce emissions. This pathway represents increased use of land for agriculture, a heavy reliance on fossil fuels, and a high energy intensity with a low rate of technology development for I suppose transitioning to carbon zero technologies. RCP 4.5 is a moderate concentration pathway consistent with low levels of emissions achieved through ambitious emissions reduction strategies. This pathway represents implementation of stringent climate policies with a lower energy intensity, strong reforestation, and decreased land for agriculture due to improved crop yields and dietary changes. It's dietary changes in society.
Thank you. Derek, carry on.
So shared socioeconomic pathways to introduce societal changes rather than just purely focusing on the concentration of greenhouse gas emissions. The SSP 2 4.5 and SSP 5-8.5 that I referred to in the last sentence of paragraph 10 effectively line up with RCP 8.5 and RCP 4.5. At paragraph 11, I discuss the Resource Management Act requirements around the National Adaptation Plan for districts and regional councils. And then at paragraph 12, I set out the text in the National Adaptation Plan, the direction for local government around incorporating representative concentration pathways and shared socioeconomic pathways in developing planning documents. Would you like me to go through that text at paragraph 12?
I think that reflects what was it contained in council's, sorry, I think that reflects what was contained in Mr. Anderson, council for ORC in his presentation to us this morning. So I think you can now go to paragraph 13.
Thank you. So in considering the direction sought by Mr. Place, I consider the provision of certainty and direction must be balanced against the ability to utilise the most up-to-date information and the methodology of utilising that information not being unnecessarily complex. Paragraph 14, the National Adaptation Plan sets out what scenarios are to be used and in what situations. As Mr. Anderson set out, the National Adaptation Plan is subject to change at least every 6 years in response to the National Climate Change Risk Assessment. Therefore, I consider that referencing this document provides the certainty sought by Mr. Place and enables the most up-to-date information to be utilised, whilst not unnecessarily complicating the methodology or repeating the content of the National Adaptation Plan. And so paragraph 15, I propose that limb 3 of APP6 step 1 may be amended to the likelihood assessment shall include consideration of the effects of climate change and should use the shared socioeconomic pathway scenarios or representative concentration pathway scenarios as set out in the National Adaptation Plan. Moving on to the application of APP6, at paragraph 21 of his opening statement, Mr. McLennan sets out the intention of APP6 and particularly table 5, the consequence table. I know that pre-hearing conferencing with submitters sought to clarify the application of APP6 as a tool for both plan change and review processes and consideration of resource consent applications within natural hazard areas. In this regard, step 2 of APP6 provides 2 pathways. The first being table 5, the consequence table, when considering plan review or plan changes. And secondly, the list of matters 1 through 11 as the primary consideration for resource consent applications. Mr. McLennan recommended the incorporation of notes in this regard at paragraph 472 of his section 42A report. I agree with.
Can I just interrupt you there, Skelly? Those references to table 5, that should be table 7, should it? Yes.
No, this is table 5, the consequence table.
Yeah, table 5 in the RTS is actually about wild conifers. So table 6 in Act 6 is the likelihood scale, and table 7 is the consequence table.
My mistake. Yes, table, the consequence table, most definitely.
Right. Okay. Thank you. sorry, I interrupted you at paragraph 17.
Paragraph 17, I agree with Mr. McLennan's summary of the application of APP6 and support his statement that amendment to APP6 is not required in response to these submission points. Moving on to the trigger for a quantitative risk assessment. The submission of Otago Regional Council seeks amendments to Table 8, the risk table, and the trigger for when a quantitative risk assessment at step 4 would be required. The evidence of Mr. Place provides a case study example working through the qualitative methodology in APP6 and considers that the assessment undertaken at steps 1 through 3 does not align with the requirement to undertake a quantitative assessment at step 4. To address this, Mr. Place has provided alternatives for Table 8, the risk table. A Genius Science letter report that I authored, referenced as Kelly 2022, sets out previous advice that a quantitative risk assessment should be required if the assessment undertaken at step 3 resulted in 2 out of the 3 scenarios having a tolerable or significant risk. Following pre-hearing conferencing with the Otago Regional Council Natural Hazards team, the below amendment to Table 8 was proposed. And that's around the hatching of when a quantitative assessment is required. These changes result in the requirement for a quantitative risk assessment being more closely aligned to the advice I provided in Kelly et al. 2021 and Kelly 2022, and that some tolerable risks will require a quantitative risk assessment. In combination with the recommended amendments to the consequence table and Mr. McLennan's summary, section 42A report, I support the changes to Table 8, the risk table, and the requirement for a quantitative assessment to be undertaken where scenarios are found to be catastrophic or major with possible, likely, or almost certain likelihoods. And that concludes my opening statement. I'm happy to take any questions.
Thank you, Mr. Kelly. So, Commissioner Cubitt first. Thank you.
Thank you, Mr. Kelly. I don't have a lot of questions for you because my issues have largely been dealt with, but just in terms of the section 42A report, in relation to step 2 and the submissions around that, this is on page 105, paragraph 439. I think a number of submitters requested that past natural hazard events get expressly recognised in that list of scenarios. You suggest that they're probably inappropriate, and I was just trying to work out on what basis, because I'd understand that they'd probably actually give you a fair indication where there's a likelihood of a natural hazard in existence. So can you just expand on that?
Yes, yeah, no, and you're absolutely correct that the sort of past natural hazard events are useful in helping to determine where natural hazard events could occur in the future. I think the submission points, though, sought to be relatively kind of rigid in that they sort of didn't allow us to consider the kind of full suite of potential natural hazard events. And so we don't want is a situation where we're sort of locked in only considering events up to a certain scale or events of a scale of past events, if that makes sense. We sort of want to be able to consider a much wider suite or much wider range of natural hazard events. So if we were to sort of lock in past natural hazard events in that instance, I'd be concerned that larger events wouldn't be able to be considered.
Okay, I just thought that might be a useful starting point at least. Just out of interest, in that same paragraph, in your quote, in the third paragraph, you used the word not agnostic in relation to natural hazard areas. Did you do that deliberately, or is that, I'm not sure how.
So I think the context in which I use the term agnostic is that natural hazard areas are agnostic in terms of the underlying zoning. So what we often find is that regardless of whether an area is zoned for residential development or residential uses or industrial development, natural hazards are often utilised or often represented as overlays on top of those.
Okay, thank you. The only other question I had of you was in relation to table step 3, and just in the notes to the table, table 8, I think it is. It says table 8, but it maybe is that meant to be table 3?
Table 8 being the risk table. I think there seems to be some mixtures in terms of the table numbering in the section 42A report. If we're talking about the risk table, yes.
Yeah, so that risk table, it's like a placeholder, I guess, until district community scale risks have been developed. What's the likelihood of, once you go through that process, that table, risk table would change? And I guess related to that is the concern raised by QLDC. If they go through that process, then they can probably actually deal with their concerns anyway, couldn't they?
So I couldn't deliver a sort of percentage chance of the likelihood of that table changing. I think the more important factor is that territorial authorities go through a process with their communities in which their understanding of acceptable, tolerable, and significant risk is found to be reflected in that table. In sort of, I suppose, lieu of that table being developed in consultation with the community, there's sort of only one community consultation process that's been undertaken to develop that table, which was for the Bay of Plenty regional policy statement.
Yeah, okay, so, but once those communities come to do that, then QLDC can probably resolve their own concerns around that risk table, can't they, through that process?
I would expect so, yes.
Yeah. Okay, that's all I had. Thank you very much.
Thank you.
Commissioner Sullivan.
Yeah, thank you. Just in relation to Act 6, and I'm referring here to, I won't necessarily use the table numbers because you're obviously a little bit different to the risk table in step 3. And I suppose looking at this against the policies, where we've got policy 4, which is about reducing to a tolerable or acceptable level, and then P5 only applies if something significant or irreversible, so it doesn't apply to tolerable. And sort of putting it in the context of that, I suppose I'm just looking at if something's likely and major. When I look at steps 1 and 2, I think, oh, crikey, I wouldn't really like something like that to happen. But likely is once every 51 to 100 years, so or 1% AEP event. How much certainty is around that, particularly when you think of the weather events we've got around climate change, and that some of this modelling when we're looking at past events isn't necessarily going to apply overly well to what we're seeing now or in the future. I suppose I'm just sort of looking at this and thinking the way the policy framework is sort of linking into this risk table are likely in major events. Is it actually going to be tolerable when, if there's uncertainty around that, it might be happening a little bit more than is expected?
I think as I responded to previous questioning, the risk table is treated as a placeholder for communities in lieu of undertaking their own assessments. And so that is subject to change. In terms of getting to the risk assessment, sort of having come through steps 1 and 2, they rely heavily on the information that the Otago Regional Council Natural Hazards team hold on both hazards and climate change. I understand that they've got a effects of climate change report from NIWA dated 2019, and that sets out the effects of climate change in alignment, I suppose, with the representative concentration pathways that we've sought to include in the methodology here. And I think then that Jean-Luc and his team are probably better able to speak to the suite of work that they're undertaking that would be able to support this methodology.
Okay, I mean, this might be sort of a planning question, partly planning question too, and that I suppose, for P4, it's sort of saying if you're reducing an existing natural hazard risk to a tolerable, which would include something that's likely major, that's kind of as far as we're planning to go with these things. And I'm just thinking, well, what's the actual cost of that to the community, particularly where some of these risks might be a little uncertain, and particularly you wouldn't have to take a precautionary approach for something that was likely major as well, because it's would be deemed as tolerable there. And granted that you'd have to then do a quantitative risk assessment for that now in terms of the amendments in the community, but yeah.
Sorry, I'm not sure if there was a question.
Oh, sorry, I'm now looking at my next next question. I was just interested in what the given that you're proposing quantitative risk assessments for a wider range of risks, what's the sort of cost around for a quantitative risk assessment? If it was a sort of a subdivision proposal or a new industrial development or something like that, what additional cost would it be adding on?
I suppose it depends on how far through the risk assessment framework or APP6 it would need to go. We have been sort of developing the methodology sought to keep the costs as low as we can through the use of only using 3 scenarios. I would expect if GNS Science were to prepare a quote for such an assessment, we would probably be looking in the order of $50,000. That's sort of going right through to a quantitative risk assessment. But it very much depends on the development. I think I would note that as a first kind of gateway to getting into this, that development would need to be in a natural hazard area as well. So it's not all developments that we're capturing here.
Okay, no, thank you.
Just to get clarification on that last range of costs that you provided, do I understand what you were responding to? Commissioner Sullivan was saying that 50K might be the all-up cost if you were involved in an assessment through steps 1 to 4 in total.
For the example that she provided, that would be my expectation, yes.
Yeah. And what sort of level of expertise and knowledge or experience would people undertaking those sorts of assessments need to have?
They the expertise that is required for these sort of assessments is typically held at sort of multidisciplinary consultancies. I would want to provide some specific examples. We also have experts at Genius Science that are able to undertake these assessments. I know that in the Otago region, Queenstown Lakes District Council are going through a process for Brewery Creek and Reavers Lane and the debris flow hazards that are there. They had reports prepared by both Becca and Genius Science to support that process.
So you're saying that most of the major engineering consultancy firms will have sufficiently qualified and experienced people to be able to provide that on a broad range through the country?
Possibly not all of them. I wouldn't want to speak for all of them, but a handful do, yes.
Right. So is it akin in terms of experience and expertise to, the layman's concept really of geotech engineers in different areas?
Yeah, it's slightly more specialized than geotech engineers, but it is akin to any technical assessment that might be required for or needed for a plan change or resource consent process.
Right. In essence, and this might sound a bit blunt, but in essence is the response that's come from QLDC and now accepted by Mr. McLennan to broaden the application of the quantitative risk assessment process being generated by the fear that there may be one or more deaths as a result of what could otherwise be described as probably unlikely or likely or possible events of moderate or major risk.
Yes, I think that QLDC did cite the number of deaths in the consequence table and how that carries through to the risk table as being of concern for when a quantitative risk assessment is triggered. Since the proposed regional policy statement, Mr. McLennan and the Otago Regional Council Natural Hazards team and myself have had discussions around changes to both the consequence table and the risk table that we think address the concerns of QLDC. They were also concerned about the trigger for a quantitative risk assessment not capturing some events that they considered should be captured there, and those changes we consider also, or I consider also address those concerns too.
In simplistic terms, how would you describe the value that is added by the quantitative risk assessment process being added to the risk table?
It's incredibly valuable, I think, for councils and applicants to understand, I suppose, numerically or quantitatively, what the risk of a certain hazard in development or zoning of an area is going to be. The inclusion of the quantitative risk assessment came following feedback from Queenstown Lakes District Council, where I understand they have a couple of cases in which development was sought in areas that they considered to be high hazard, and they found that they didn't have a framework or a information requirement in order to be able to properly assess those risks. I understand that examples in the Bay of Plenty and Matata have also been sort of raised by the panel, and you know, those that undertook that plan change process for Matata have said that that retreat or change in land use for Matata following the debris flow event there wouldn't have been able to occur without the risk assessment methodology and the quantitative risk assessment methodology that they have in that regional policy statement.
So you're really saying that Matata, had there been a quantitative assessment, risk assessment carried out prior to the development of that residential area there, that would have shown a level of risk that was likely to have led to it being declined.
I'm saying that so Matata was a managed retreat case in which there was already development there, and then a hazard event occurred in 2005. The council sought to manage that hazard, whether it was through engineering or warning system options, but they weren't practical, and so they undertook a risk assessment process in which the residential land use on that debris flow fan was discontinued through changes to their RPS and the district plan.
Right. And what you're saying to us is that the science behind that required a quantitative risk assessment, which gave a base for those changes that led to the removal of the ability to residentially occupy that fan.
Yes, yeah, that's correct.
Yeah, right. Just one final technical thing that I probably should have asked Mr. McLennan, but so either of you can answer really, but just looking at, all right, gotta find my place. It's one of the steps, step one. Yeah, it's step two rather. Notes 1 and 2 to step 2 both use the term territorial authorities rather than local authorities. Should that not be local authorities in each case of those recommended notes 1 and 2?
Just finding the context of those.
Look, rather than us taking time, could you and Mr. McLennan have a look at that and have a chat over lunch, and after lunch come back to us and just confirm whether or not we should be, whether you're recommending that the wording is territorial authorities or local authorities for each of those notes. All right.
Yes, thank you.
All right. Thank you, Mr. Kelly. Thank you very much for your input, both in writing and today. Thank you.
Thank you.
Now we'll move to submittals, and starting with you, Mr. McIntyre. Thank you.
I believe that Ms. Bartlett is also present remotely.
Ms. Bartlett, you. Thank you.
Yeah.
Hopefully Ms. Bartlett will come online.
I'm sure she will.
So that I'm sure you can carry the day if need be. So,
She was emailing me earlier, so I know that she has been listening.
all right, well, you carry on.
The cultural evidence for Kaitahu drew attention to several interrelated concerns associated with living with natural hazards. These include the effects of coastal erosion on native reserve lands and urupa, risks to mahinga kai arising from the effects of coastal hazards on water and wastewater infrastructure and closed landfills, and implications of climate change exacerbating existing hazards. Responses to natural hazard management can include restricting activities in hazard-prone areas and or directly protecting areas from the effects of hazards. And both types of those responses have implications for the recognition of kaitohu taka over their ancestral lands and their taonga and their ability to exercise kaitiaki taka. So the main focus of my evidence on this chapter is to ensure that rangatira taka and kaitiaki taka are appropriately enabled and that effects on the matters of concern to kaitahu are clearly recognised. And if you want the reference to the paragraphs in my evidence in chief, I've put those in a footnote. And my recommended amendments are on pages 42 to 44 of my appendix 1. Policy is NHP 11, which has been discussed this morning already, that provides for kaitahu participation in decision-making about hazard management affecting native reserves, Māori land and Waihi Tupuna is central to the aim I've outlined. And it's already been discussed this morning. There was a lack of clarity in the original wording, and so Mr. McLennan recommended deleting it. I asked for it to be reinstated, and Mr. McLennan initiated some recent discussion to have another look at that, and I'd like to thank Mr. McLennan for initiating that discussion. It's been very helpful in focusing us on what the key components of this policy need to be. Where we got to in that discussion in terms of agreeing on wording is that we identified, as has already been discussed this morning, that there are two parts to the policy. There's the approach in terms of natural hazards, natural hazard risks affecting native reserves and Māori land, and then there's the approach in terms of Waihi Tupuna. So to come up with the eventual wording that we agreed on, I went back to the policy approach that is used in the RPS for those two aspects and tried to come up with wording that aligned as closely as possible to the respective approaches for those matters. So for the first part of the policy, I went back to the wording that is in MWM4 and MWP4 and particularly MWM5, which is where the reference to leading approaches to management on native reserves and Māori land has come for. That is directly reflecting the wording that we've sought in MWM5. Noting Commissioner Kirikiri's question this morning about why we haven't got recognise and provide for in there, I had a look back this morning at MWM5, and I've realised that the reason that has happened is that in looking at aligning the wording, I only looked at a part of that method, and that method does start with provide for by recognising the rangatira taka. And I think to be consistent with that, it would be appropriate to start this policy by the words recognise and provide for the rangatira taka. I have the same concerns as Commissioner Kirikiri about just recognising, not really leading to any action necessarily. In terms of the second part of the policy, which is looking at management of hazards affecting the values of Waihi Tupuna, in that case, we went back to the policies in the Waihi Tupuna section of HCV chapter, and in particular we looked at objective 1, and I think, I haven't written down the method. Mr. McLennan's statement. But there is a method in the Waihi Tupuna. Yes, method 3 in the Waihi Tupuna section, which has wording which is very similar to what we have agreed on for B in this policy. Noting also Commissioner Crosby's question about whether we're managing natural hazards or the risks of natural hazards. I agree that we are predominantly managing the risks. Managing the hazards themselves is something that is a much larger task, which is probably beyond us. And I think that could be addressed by just referring to natural hazard risks in this policy. The areas where the native reserves and Māori land are located are predominantly in coastal areas, and so use of these areas will be affected by the approach to management of coastal hazards. As has also been discussed this morning, coastal hazards are treated differently in the RPS from other natural hazards, and in my evidence I've highlighted a lack of clarity about the methodology to be used to assess the risks of coastal hazards and the approach to be used in areas that are affected by a combination of coastal hazards and other hazards such as riverine flooding. Mr. McLennan this morning has helpfully pointed to the guidance on the New Zealand Coastal Policy Statement, which indicates that hazards such as riverine flooding that are in the coastal environment will be considered as part of the coastal hazards. So that addresses some of my concern there, noting that there's always going to be some uncertainty about where you draw the boundary of the coastal environment, and if you have a different approach being taken in the coastal environment to outside the coastal environment, then there is going to be a real need to look at how you integrate management of hazards across that boundary. And I just note that because I think that's something that the council will need to think about, maybe something that is worth flagging in the policy direction in this, that need for integrated management may be worth flagging in the RPS. In terms of the question about assessment of the risks in the coastal environment, that I don't think has been resolved. Mr. Anderson and Mr. McLennan this morning and Mr. Kelly have talked about the National Adaptation Plan, which does provide some direction in terms of assessment of the risk of coastal hazards. I haven't had the opportunity to look in enough detail at that to get a real handle on whether it is sort of an equivalent to the type of approach that's set out in Appendix 6, whether it has that level of detail or whether there is something needed in addition to it. That I think again is something that probably Mr. Kelly and Mr. McLennan would be better qualified to do than me. But regardless of whether it does or not, I think there is still a gap in terms of the policies in the chapter, in that there is no policy that specifically that actually refers to assessing the risks of coastal hazards. So there is policy 1A and policy 1 both talk about identification of hazards in the coastal environment and outside the coastal environment. Then policy 2 goes on to set out that appendix 6 is the methodology that will be used to assess hazard risks outside the coastal environment, but there is nothing that tells you how you assess the risks in the coastal environment. And I think it's important that territorial authorities in particular who are preparing hazard overlays have some direction on that. There is in the policy 24, because it refers to policy 24 of the NZCPS, policy 24 of the NZCPS sets out a number of contributing factors to hazards that need to be considered in assessing the hazards, but it doesn't tell you how to assess those hazard risks, and in particular it doesn't tell you, it doesn't refer at all to the sort of likelihood and consequence of those risks, which is what Appendix 6 does. I haven't proposed any means of addressing these because I think it is something that Mr. Kelly and Mr. McLennan need to have a look at, but I think there is a gap there. In addition to the matters above, I've made recommendations in my evidence to provide more clearly for consideration of, firstly, the effects of climate change on natural hazards and on management of closed landfills. Mr. McLennan this morning has talked about the method relating to closed landfills, and I'm comfortable with the wording that he's proposed in relation to that method. In terms of the effects of climate change on natural hazard, I proposed on page 42 of my appendix 1 some wording referring to those effects in policy P1A, which Mr. McLennan hasn't at this stage accepted. The wording I've proposed is, at the moment it says identify areas that are potentially affected by coastal hazards, including tsunami, giving priority to the identification of areas at high risk of being affected. I've proposed adding in, including where these may be caused or exacerbated by climate change effects, to make sure that that is clearly considered, and that's linked to the Ngaitahu submission generally saying that climate change effects have not been fully integrated across the RPS. I've also made recommendations seeking consideration of the effects of heart protection structures on Kaitahu values, natural processes and ecosystems in NHP 7, and the effects of waste management facilities on Kaitahu values, including the values of Waihi Tupuna, and that latter one has also been discussed a bit this morning. In respect to the former one, has NHP 7, the effects of heart protection structures. Mr. McLennan has suggested that referring to the specific effects I've identified could inadvertently limit the consideration of other relevant effects. My evidence proposes making the policy non-exclusive to address that concern, but on reviewing my appendix 1, I note that I haven't proposed wording that makes it non-inclusive. So I have suggested in my summary essentially addition of the word including to the reference to those effects that I had asked for in my appendix 1 to do that. And I set that out in my summary. There are also a few objectives and policies for which I have proposed a bit of refinement of the wording just to make them clearer or to make them consistent with wording elsewhere, and my evidence at paragraph 154 refers to the objective policy method where I've done that.
Thank you. Question Hewitt.
Yes, thank you for that, Ms. McDoy. Your evidence is very clear, but the only question I had was the one I raised with Andrew around the implications of two different processes in relation to land within an area that may be affected by a natural hazard, and whether you had any comments on that. I'm probably now to the point where that possibly is actually more of a process thing rather than what the outcome may be. It's how it.
Yes, it is. It is all about process. I mean, I have a number of comments that I could make on there. The first one being that with respect to native reserves and Māori land, we are specifically having to deal with the obligations in Section 6E and Section 8. So there is, that does provide some justification for a different approach to other land, and that there is an obligation to give effect to the principles of the treaty and to provide for the relationship with that land. And as I've referred to in the sort of general matters part of my evidence, what is needed to do that includes actually providing for that involvement in decision making and that ability to have a real say in what happens to that land, particularly given the history of exclusion from that decision making. In terms of the practical effects of it, first of all, I think it's the example that you referred to earlier, which may be an isolated area in the middle of a floodplain. That's not a situation which would arise in Otago in terms of these areas. The areas that we're looking at in terms of this are essentially more likely to be affected by coastal erosion and storm surge and those coastal hazards, because that's where they're situated. The management of those hazards is a bit different from management of a floodplain.
I guess.
Yeah. A couple of other things that come into that, I guess, is that you'll see, when you look at those areas, if you look at the areas, for example, where at Moeraki, Katihuerapu, Kipukitaraki and Otako are primarily located, you will see, for example, that the marae in those areas have been located on higher land, which is an indication of, I guess, the decision making that hapu make in terms of living in the environment that they're living on. I don't think that those marae are situated on high land just for the view. They're situated on high land so that they are actually protected. They are resilient to some of those coastal hazards in the area that they're situated in. So there is that general, I guess, decision making in tune with the environment, which is what hapu are used to doing. There is also, in terms of specifically looking at this question of the exacerbation of those risks by climate change, which is something that all of the hapu are keenly aware of. Ms. Stevens, in her evidence very early on in these proceedings, drew attention to the Ngāi Tahu climate change strategy, which is being developed. Part of that strategy includes Te Runanga o Ngāi Tahu working with Hapu and whānau in terms of climate change plans for their land. So there isn't a clear intention for Hapu to be looking specifically at how to manage those hazards. So I guess, in terms of the approach we're looking at in this policy, it's not just sort of something that is sitting there, put in there out of the blue. There is a lot of thinking that is going on about these matters. There are a number of marae-based communities around the Motu where there are active decisions having to be made about how to deal with increasing hazards due to climate change, and there is a lot of discussion among Hapu about those things. So I guess my point there is that I think that Ngāi Tahu communities are probably more actively considering the implications and looking at the ways in which they need to manage the risk of natural hazards than most other communities are.
Yeah, I understand the point around the coastal issues, but with the definition of Māori land sort of probably getting a bit broader than that, or what sort, that may take it out just the coastal realm. There could be wider implications there. And my concern is really, regardless of ownership, there will be management requirements within those areas that everyone's going to have to deal or follow.
Again, in terms of the point that I've just made about the climate change strategy, again, part of that strategy is to be actively looking at those questions of management of risks and resilience to risks, including in terms of when new land is acquired and that sort of thing. So that the consideration of the impacts of climate change are going to be part of any decision making about use of new land in the event that new land is acquired. What's more likely to be happening in terms of acquisition of new land is that the Rūnaka are going to be looking to acquire land which is less vulnerable to natural hazards, to be able to relocate families from land that is more vulnerable. And that is one of the key reasons why we sought to have that broader definition, so that it would provide for that. That is what the Rūnaka are looking at the moment.
Okay, thank you.
Sandra. Most of my questions were answered even earlier on by Mr. McLennan, actually, but you've just sort of confirmed them. I mean, on the CLP18 question, which I did raise with Mr. McLennan, you did indicate that it was something that you hadn't discussed yet, or not to the same extent that you did the other stuff, and which kind of leads me to, I suppose, first of all, just to acknowledge the fact that the conversation is ongoing, which is kind of neat. From our, people are, you're still able to talk and make points that perhaps initially weren't really fully understood or appreciated, and being able to sort of fashion things. So I'll just leave that to one side, but you just mentioned something else, or if you want to say something about it.
I would like to just briefly comment on that that policy. I've always had a little bit of an aversion to policies and statements and plan just making general references to adverse effects on, dealing with adverse effects on the environment. That doesn't provide clear direction for anyone. So my preference is generally to be clearer where you know that there are going to be particular types of effects, to specifically refer to those effects rather than just having these vague general type approaches. The direction that is in the Waihi Tupuna section, which Mr. McLennan has referred back to, is quite general. This is a policy which is specifically a policy about management of waste treatment and disposal facilities. It is a specific policy, so I consider that it's appropriate to have some specificity about the types of effects to be considered, where those effects are ones which are significant effects, and the effect of waste treatment and disposal facilities being located on Waihi Tupuna is a concern which is regularly expressed by Manawhenua, because of the effects on the Māori and the effects on the ability to carry out sort of traditional uses of those areas. So that's the reason why we've asked for it to be specifically referred to.
I guess what I was alluding to is the fact that the ability to find some common ground needs to just, it's there, and you've already demonstrated that. But a comment you made earlier on, it just piqued my interest around all your marae being built on hills, right? Now, I want to just swap that to urupa, because there's the same issue around urupa and marae on hills. Right, do you have a comment?
I am less familiar with the locations of the urupa than I am with the marae. I know that there are concerns. I know that Moeraki in particular has concerns about, because they have an urupa which is very close to the coast, and that is a coastline which has has been experiencing accelerated erosions.
Because David mentioned it.
I think Justin Tupper mentioned it. That's right. That is a live issue, and I guess that is one of the, and Justin Tupper referred there, I think, to the frustration of essentially being left to deal with that issue on their own without the local council, apparently being prepared to do anything about it. I think that is a clear instance of that importance of being involved in the management of the risks on that land. Yes, in terms of the location, I mean, my guess is that the location of that urupa was originally further away from the coast than it is now. There has been a lot of erosion along that coast.
I just remember David raising it up when he mentioned it, and I just completely forgot about it. Yes, but it also though raises the broader issue of urupa generally, not just in a hazard space, but every space. There's lots of other spaces that urupa, which there's peppered through this. There's a little bit here and a little bit there, but I don't know. In your opinion, I mean, do you think that you've given it, or the council has given the urupa question the right attention?
In looking at the direction of policies across this RPS, the effects on urupa were one of the things that we looked at, that we were certainly very conscious of in terms of looking at things, I guess, and that is one matter where that policy that we've just talked about the location of waste treatment and disposal is clearly an issue. You wouldn't want a waste treatment site next to an urupa. In terms of the management of urupa, in most cases, the way in which that gets looked at needs, there is, in terms of this RPS, I guess the key place in which it's looked at is in terms of the policy in relation to the use of native reserves and Māori land. The urupa are generally on reserve land. So the recognition and provision for rangatiratanga in terms of the use of that land applies to urupa as well. In terms of the more general question of, say, effects on neighbouring lands that may affect urupa, that's something which generally gets looked at in the detail of a district plan. And the way in which it's approached tends to be influenced by, whatever the framework of that district plan is, what the zoning's like, those sorts of things. And it's something that is probably, in most cases, more easily looked at in that context. I think Mr. Bathgate would be able to comment more on that than me, because he's been much more involved in looking at those issues related to district plans. But certainly he has thought about that in terms of his part of building the submissions on this RPS.
Yeah, I'm just conscious of a whole number of resource consents that I've been involved in that have involved urupa in one aspect or another. And some of them have been quite serious things, like residential developments alongside urupa sites and a whole bunch of those things.
I guess in Otago, one of the, I've talked in my evidence about the history of the development of native reserves and the sort of lack of recognition of residential activity being there. But I guess one of the benefits of the fact that those have generally been zoned as rural land has been that there has been less pressure in terms of neighbouring activities on urupa. I think also there are not the same concerns as there have been, say, further up in Canterbury, where you are much more likely, for example, to have something like intensive farming right next to an urupa. The areas in which the urupa are located in Otago are not areas where intensive farming is happening, so they have been a bit protected by that, really.
That's all I had. Thank you very much.
Thanks, Sandra. My questions have actually been covered off by your introductory questions, so thanks.
I didn't have any particular questions to ask you, Mr. McIntyre, but you have raised a very interesting issue that I want to raise with Mr. McLennan. I'm not sure if Mr. Kelly's still on the line or not, but it relates to the recommended changes that appear in the version that we've been given for HANZ NHM3, and it's recommended to be amended by deleting the reference to Act 6. So it's touching on the point that Mr. McIntyre raised about there being no assessment of the Act 6 in respect of coastal hazards as contrasted with natural hazards. But it then goes on, the recommended wording went on and said, and the outcomes of the risk table established under HNZ M21. And then when you look at that, it of course says that local authorities must work collaboratively to assess the level of natural hazard risk in their region or district in accordance with HNZ P2 and AP6. And it goes on with A, consulting with community stakeholders and partners, kaitahu, including with local authorities in neighbouring regions regarding risk level thresholds. And then B, developing a risk table in accordance with step 3 of AP6. So as I read that through, it didn't seem to accord with what Ms. McIntyre was saying. But then when I went back to your original report at paragraph 62, the amendments that you recommended there didn't seem to include that amendment to M3.1 that I've just read out to you. And when you look at the body of your report, at paragraph 57 in particular, you are referring to the difference between, or the result of the existence of policy 25 and NZCPS, creating a difference in terms of the way in which management of effects is to occur as between coastal and natural hazards. And you then reach a conclusion that given section 61(1)(da) of the RMA requires reports must be prepared in accordance with the NZCPS, I recommend that HNZ P10 is amended to remove the conflicting policy test by removing the references to policy 2 and policy 3. And I wondered whether, in retrospect, in reality, you meant that to remove the reference to P2. Was it necessary to do that? The reference to P3 I can understand, because P10 is covering coastal effects management in P10 for coastal hazards, and P3 is for terrestrial, as I see it. But P2, it seems to me, not that it's in the actual recommendation of paragraph 62, but it is in the amended version that we've been given, that there is still a reference and a requirement for a risk assessment in terms of AP6 for coastal hazards in the methods at M3, or by the combination of M3 and M2. I'm sorry, that's all a great trail that I'm.
No, I think I was following that. Yes.
Right.
Yes.
So look, again, I don't want an off the cuff response from you, but I think it's important for us in the context of these hearings today and tomorrow to have a response from yourself, Mr. Kelly, if you can.
Yeah.
And is it just a simple matter of at P2, where that wording at the start, now recommended wording within areas identified under P1 as being subject to natural hazards, could that simply be P1A and P1? In other words, on my look at Appendix 6, it doesn't seem that there's any reason why that should not be applied. And in fact, the methods seem to require it to be applied for coastal hazards as well. And if that is the answer, when you and Mr. Kelly think about it, if that is the answer, yes, that's what was intended in the overall thrust of things, then it's the simple answer just to insert P1A as well as P1 in the opening words to P2. Right?
Yeah, we can look at that.
Okay, good. So look, just as and when through the course of the day or tomorrow morning, first thing possibly, might be easiest for you to be able to talk to Mr. Kelly. Okay.
Sure. Thank you.
Thank you. Thank you, Mr. Nicola.
And Ms. Bartlett is up here.
Oh, yes. Right. Ms. Bartlett, is there material that you're wishing to add? I'm not sure whether you've heard the exchanges with Ms. McIntyre or not.
I have. I've been listening all morning and following proceedings. So there's actually only one point in my evidence that's left outstanding from all of the discussion and the amendments that have been negotiated. So, and delivered by Mr. McLennan. The one outstanding matter from my evidence is the definition of hard protection structure. I'm in a different place to Mr. McLennan. I was waiting to hear whether or not he had thought a bit further based on what I had in my evidence from paragraph 28 through to 31. and that I'd offered up an alternative recommended change. He's putting reliance on the phrasing specifically established for the purpose, i.e. a hard protection structure is specifically established for the purpose of natural hazard mitigation. I observe in my evidence that that can be a secondary purpose of a structure, and I don't think that's I didn't think that was the intention, and I didn't pick up an intention other than to have a hard protection structure speaking to the primary purpose of a structure. And the reason that my evidence spends some time here is because of the relationship with dams, weirs and reservoirs, and so that obviously has an important link to freshwater management and all of the positioning of Ngāi Tahu ki Murihiku around Te Marotowai, and so we've got this intersect happening in the definition of hard protection structure between hazard response and climate change response and freshwater management. What I was really looking to tease out, I was hoping to see a bit more of the thinking of ORC in relation to particularly dams and natural hazard risk management. I still haven't heard that. So that's something to pick up a little bit further and when we get on to the land and freshwater chapter discussions. But in the meantime, if we can get tighter about the relationship of the definition of hard protection structure, that kind of could potentially narrow the conversation when we get to the land and freshwater chapter. So the recommendation I'd offered up was actually drawing from the Forest and Bird submission, and where they'd used some phrasing that described primary purpose. And it seemed to me that that was a really good way to cut through the issue. And that actually, I'm presuming that in the natural hazard chapter, and when you're using hard protection structure in relation to natural hazard risk management, you want those structures, you want to be talking about structures that have a primary purpose of natural hazard risk management. Yeah, and there's wider considerations there. In my evidence, I gave the example of fire risk and ran through policy 7, NHP 7, thinking about fire risk. I think it shifts again when you start to think that natural hazard risk includes drought risk. Because one way in which you manage drought risk might be a proliferation of dams, or it might be addressing water demand in dry areas and areas that are getting increasingly dry. So you can see hopefully what I'm driving at. And I didn't hear from Mr. McLennan that he'd thought about this further after reading my evidence, so I'm putting it on the table. I think I stand by my recommendation of introducing the phrasing primary purpose.
And if I can just add, Ms. Bartlett's recommended wording is included at the top of page 42 in my appendix 1.
Can I just ask you to respond before I ask if other commissioners have any questions? What's the nub of the problem or the concern that you have though?
So I think what I was trying to find out, I suppose, was whether ORC are being intentional, for instance, around assessment of drought risk and fire risk in the region, and then determining that dams are a favoured response to analysis of that risk. I wanted to understand then what it means if the obviously P7 will still have an interaction with what's sitting in the land and freshwater chapter that needs addressing, and I think with the additions that Sandra has proposed in her evidence, that brings in matters of importance to Kaitahu when looking at hard protection structures. You know, that's a really helpful addition. I think what I was looking for, though, was an evidence of a conscious analysis in including dams and reservoirs in the hard protection structure definition in its relationship to the policy suite, and particularly P7.
Well,
I wasn't sure that it was.
Thank you for that explanation, but I wondered what I'm just trying to get a grasp of. Are you able to give us a practical, factual example of the type of concern that you've got?
Oh, okay. So I'm thinking that we do have a lot of dams in Central Otago. It is probably it's in this sphere of increasing risk to both fire and drought. And where, for instance, increased irrigation storage options start to come through, and we're anticipating that to some extent, because there's, I think, been a bit of underinvestment over time, that we may see that increased investment and application of P7. At the moment, an applicant, for instance, could be coming forward with an irrigation-driven proposal and simply identify that there's specifically an intent to use the structure also for management of fire risk or drought risk, and that would have been enough to satisfy P7. Whereas perhaps if you were only driving from a natural hazard risk management perspective, rather than firstly from an irrigation perspective and then tacking this on, you might come to a different solution in terms of size or scale or positioning, location, that kind of thing. That's really what I'm getting at. I want this to be very clear. And
that's a good explanation. Thank you. And I didn't have that clear picture from you before. So look, there may be other questions from other members of the panel. Questions?
No, thank you for that. I don't really have any questions about it. Yeah, in relation to that specific issue you gave, I am aware that not even just dams, there has been some development of the connections to irrigation schemes that can be used for firefighting and so forth. So I think that's where your concern is coming from, that it could be a driver for that.
That's right. And I think, for instance, I also look at fire risk and drought risk quite differently as well. I think drought risk is tied to land use, and it's tied to where activities are happening and why drought becomes an issue. It only becomes a need for response when there's an important human use component, which might be drinking water, or it might be irrigation supporting economic activity. So that's quite different to fire risk, where you might want a response because you're actually, the impacts are wider than just consideration of how water is used by a community. And when you're talking about drought risk and you're talking about how water is used by a community, one thing that you do have at your disposal is water demand control and land use control, for instance, those kind of things that you might use to respond to the risk. And so all I'm indicating there is that moving to the solution is dams in response to drought risk is one potential response, but it's not the only potential response.
Thank you.
I don't have any questions, but I just want to raise an issue around things like nohoanga.
Mm-hmm.
You know, I mean, you're referring to the issue around dams and weirs and stuff like that, which have, as a part of that, there's a mahinga kai component to it, and the fire risk and all the other risks you're talking about here. And I'm assuming, on the one hand, that nohoanga come under a big, there's an umbrella above all that, but at the same time, they are actually quite unique. They're quite special, and I guess what I'm seeking is some sort of commentary around risks and hazards associated with nohoanga, particularly those around water locations.
So I think the simple answer is that, well, I think there's two dimensions to the answer. One is what's the natural hazard itself doing to threaten use of nohoanga, and then the second part is what is the human response to natural hazard risk doing to nohoanga. Probably the part of my evidence that's focusing on the human response would want to understand the relationship between use of structural interventions and what that does to nohoanga upstream, downstream. So I think that's where the changes put forward by Sandra become important in terms of the use of structural interventions. In terms of what we do about the risks represented by the natural hazards themselves in relation to nohoanga, I think that is that's a really interesting question. It doesn't obviously come under the conversations you've been having, well, sometimes may come under the Māori conversations you've been having, but it's more likely that nohoanga are sitting outside land owned by kaitahu. And because I hadn't thought about this question ahead of today, I could have a bit of a look through and look at what's sitting in the RPS that would provide us with some sort of response to that. Yeah, I haven't, and Sandra may want to jump in if she's got some thoughts at this point, but I think that's an analysis that could be done that I haven't done.
Yeah, I mean, to be fair, I hadn't done it. Just sort of.
It's a good question.
Occurred to me.
Really good.
And I think nohoanga is a very good example of the sorts of things that we are wanting to deal with by that reference in Policy 7 to effects on natural processes, Indigenous ecosystems, and kaitahi values. Stop banks can potentially cut off. Those sorts of things can have significant impacts on whether a nohoanga is actually of any practical use. So I think it is a really relevant example in terms of that policy, and also the P11 that we've been talking about today in terms of that involvement in decision making in relation to a tupuna. That type of response to managing hazards, particularly when it involves hard protection structures or modification of river channels and those sorts of things, has some quite significant implications for areas like Moana.
Yeah, so I think that bit I'm comfortable is covered. It's more, have we thought about how the provisions give us something to work with to undertake an assessment of the risks to nohoanga, natural hazard risks to nohoanga, that then drive us to determine a response? I think that's a slightly different question, and I don't know if we've thought that through enough yet. I'd be happy to sit and do some work on that and come back promptly. Yeah.
Yeah, I'd look forward to that.
Yeah.
That's all I had. Thanks very much.
Thank you, Ms. Arthur. There are no further questions from the panel. Thank you.
Thank you.
Ms. Taylor, how long do you think you'll take?
Not long.
That's what I thought.
Yeah.
So we're so late that I wouldn't have made that offer to you, but if it comes forward. Yeah.
Is that a panel's not long or a lawyer's not long?
No, definitely not long. I think I don't have anything written to hand out either.
Right.
So I'm meant to appear for Contact and Oceania Gold, but I thought I'd just combine them into one quick session. This was this afternoon.
Yes.
And yeah, I don't have anything additional than what's in my main evidence anyway, but I just thought it might be useful to run through a bit of an example of how the hazard provisions in particular would apply to both those clients. So for Contact, obviously they have the Clyde Dam in Pluta, which is within probably a high natural hazard area, given its river type environment. And the dam itself is also classified as a building. Therefore, I'm just not sort of clear as to how Appendix 6 would really be applied in that sort of situation. And whether it possibly doesn't need to, given that it's an existing activity. It's just sort of those types of examples that you run through Appendix 6 that doesn't quite add up as to how that would work. The same sort of issues apply for Oceania Gold. Their tailings facilities are classified as dams, which would therefore be buildings. And they do develop new ones of those from time to time. And again, so they've got sort of landslides, earthquake type risk. So the likelihood of that might come under the likely under table 6 in Appendix 6. And then you go to table 7. And because it's a building, I'm not sure whether that would be enough if there's something was to happen. For example, there's a landslide and maybe the perimeter got compromised, whether that would be 100% of the buildings within that hazard area have been compromised. I'm not sure. When you run through those sort of site-specific examples, it's not clear to me how it would work. I appreciate this for land type planning and zoning works quite well. So I have no issues with the sort of approach and structure on that basis. It's more for those site-specific activities and resource consents.
Right. Well, I'll open to that. We've read your evidence, obviously. Any questions?
Well, not really. The two things you highlighted is things I had notes on your evidence that I'm not sure if you're here when Andrew explained in terms of that, probably not so much dams, but it was like regionally significant infrastructure in areas that are high risk. And he suggested as you go through those steps, while there may be a significant risk there, and I'm thinking the Clyde Dam as an example, as you get through there, factoring into the actual consequences of that when design of the dam is added in, means you're probably not going to be caught.
Yeah, I appreciate that, and And if that's the intent, that's great, but it's just probably, it's not abundantly clear.
Yeah,
perhaps.
and, and that's exactly the thing that was in my head, because we've been applying this other technique to the cascade of effects for significant infrastructure through the other chapters, but this is kind of doing the same thing in different ways. The way I took Andrew to say whether it needs to be made clearer.
Yeah, I mean, I think because there is that note too, which talks about the matters set out in 1 to 11 of primary requirements for resource consent. Maybe if that's just made more strong, because when you look at the note, you know, under that 1 to 11, it says using table 7 and the matters listed in 1 to 10.
Yeah.
So you're still kind of going back to that table, and for me, the table just doesn't make sense for those examples.
Yeah.
It's the issue, really.
With moving away from contact now with oceanic, it didn't occur to me that tailings also might be a dam, because when I read your evidence, tailings is the first thing that came to mind in context of contaminated land and how that works in the avoid policy. Taking it from Mr. Anderson's legal submissions, that you probably fall within the where practicable, well, you wouldn't fall within that, so you'd be able to do it. And I think your amendments, though, just go to suggest we need to go to a reduced remedy or mitigated. And is that because of that tailing dam sort of issue, that there's going to be trace elements of contaminants in there?
Yeah,
you
so,
really can't avoid.
Yeah. Essentially, yes, that is the issue there. Well, and again, I think you touched on it earlier too with the questions about mining being on the hail list, so potentially the entire site.
I'm still not entirely sure how that's going to work, because the way councils look at that, they go, well, it's a contaminated site.
Yeah, so that is an issue
kicks
for
in,
Ocean
but-
that particular policy.
Yeah, okay, well, I understand what you're saying, so I don't have any further questions. Thank you.
Yeah, just one question for me in relation to your evidence around CLP 15. Bottom of page 34. We do have some other submissions on this as well. I know Queenstown Airport were also wanted to see remedy and mitigate specifically included in that policy as well. I was just interested in what your sort of key concerns are. Is it around the minimised, is it to the smallest extent practicable? Is that the key concern? I mean, I was assuming that minimised could involve remedying or mitigating.
Potentially, I mean, I think it is, yeah, that it is issues minimised to the smallest extent practical, whereas certainly for a site like Macrae's, there is an expectation that things will be remediated, but that's not necessarily minimised. Certainly to the point where it's remediated, that there's no adverse effects in the environment. But whether that's the same, I'm not sure that it is, given that it's using quite different language.
Yeah. Yeah. Okay. No, that's helpful. Yes.
Yeah, no, look, I didn't have any particular questions, so thank you very much, Ms. Hunter, and I'm sorry that you've been held up for so long.
Always good to listen in.
We'll see you next week.
Yeah, I'll be back next week.
Right.
See you then.
Cheers.
So we'll break for an hour. So back at 2:30.
And bring all those people so they got 5.
Well, good afternoon, Mr. McLeod. How are you?
Good afternoon. I'm meant to be joined today by Rebecca Ing from Transpower as well. So could we give her like a minute?
Right.
Speak of the devil.
When you say speak of the devil, have you seen something we haven't seen?
I shouldn't be speaking of my client in that way. Well, perhaps I should start by introducing Rebecca Ing, who's I'm not sure what her title is actually. I should have studied up on that, from Transpower, who's also joining today. If you have any questions, particularly around Transpower matters. We also have Roy Noble available if you have engineering type Transpower matters that you have questions about, and he can join tomorrow in the time slot that's also allocated to me if you need him. Otherwise, he's very happy to be excused. Shall I just go on to my evidence?
Yes, indeed. Yes.
Yeah, well, I think I can be very, very brief. There's one matter in my evidence, and that's in relation to the policy P3 and whether the policy should talk about avoiding activities or avoiding significant risks. I have listened to some of this morning and understand the intended scheme, but I think the outcome, the environmental result we're all after, and I think we all agree, is that the significant risks are avoided. And I think it would be appropriate for the policy to state what is intended more clearly. And the reason for that is that I think by referencing avoiding activities, and I know that there are some other policies in relation to hazards and risks in the RPS that talk about avoiding areas, I think there can be some confusion about what a district plan or regional plan might do to implement this policy. And I think by talking about avoiding risks, it eliminates the risk of blanket avoidance over areas being the way in which this policy is implemented. And I'm happy to take questions.
Okay, thank you.
Yeah.
Commissioner Kiewit.
Yeah, thank you, Mr. McLeod. I think you've probably been listening in today around that particular issue. There seems to be a bit of a disconnect between, I think it's policy 3, which is of concern in how that APP 6 might work when you move through determining what the risk is. There was a suggestion that, well, Andrew's explanation today was that you probably don't need that amendment to recognise functionality because of the way although there may be a significant natural hazard in a particular area, because of the design of your infrastructure, you may not actually meet the threshold. Is that how you read it?
Yes, I understood what he was saying, and I understand how the appendix is intended to work. My concern is that getting that nuanced approach into the plan provisions that might implement this, high-level policy might not be able to pick up on that subtlety. And I think that because the outcome is that I agree with the 42A report that we're looking at avoiding significant risks, then the policy should just say that.
Yeah. You haven't recommended any amendments to APP 6, it's just the policy?
No. Yes.
Yeah. Which is avoid significant natural hazard risk. Yeah. Okay, no, that's all I wanted to traverse with you. Thank you.
I've really only got one question on this particular issue, Mr. McLeod. I haven't had a chance of checking myself, but have you looked at whether or not the National Policy Statement for Renewable Electricity Generation addresses hazard risk at all?
I don't, in my evidence, I don't really traverse the MPSRG, more that MPS for electricity transmission.
Right.
And it doesn't explicitly make reference to natural hazard risk. It does talk about slight route and method selection and providing the councils with an avenue to consider that when new and significant infrastructure is developed.
Yeah, well, I was going to thanks for that, because I was going to go on and ask you about the electricity transmission MPS.
Yeah, well, my apologies. I do have some familiarity, but my evidence don't have evidence on the MPSRG.
Yeah, no,
I can certainly find out.
No, really, I only had a quick look at both of them, and I couldn't see that either of them addressed either the one on transmission or on generation. It didn't look like they addressed the issue of natural hazard risk at all. Is that your understanding? Or?
Yes, not explicitly, with the exception of obviously the need to avoid effects more generally, and that the need to consider site routes and methods when developing infrastructure.
Yeah. Oh, look, thank you very much, Mr. Cloud. And James, anything you wanted to add at all?
Apologies, is that a question for me?
Just whether there was anything that you wanted to add at all or not?
Oh, no, sorry, sir. No, thank you.
Thank you both very much.
Thank you. Short and sweet.
Yep, indeed. All right, tomorrow. Yeah. No. Tomorrow, next week. Mr. Brass.
I don't know if people, well, they might describe me as short. I'm not sure about short and sweet. But I'll try not to take too much time, so put it that way. So my evidence only had one point relating to hazards and risks, and that was regarding positive policy in HP 7. And my concern there is that some changes that have been made through the 42A report, probably at my paragraph 211, the result of those changes is it sets a significantly lower standard than the original drafting. The degree of necessity drops from essential to no reasonable alternatives, and the required benefit drops from managed risk to a level the community is able to tolerate to reducing the risk exposure. And there's no qualitative or quantitative shape around what that reduction could look like. So potentially any reduction in risk exposure, regardless of whether it's material or whether it meets community needs, would be able to pass through this policy. So to address that, I do suggest at my paragraph 215 some alternative wording. I do note that following the pre-hearing meeting on this topic, there was some discussion between planners, and I wouldn't say that my wording is the one and only way through that. Would be open to others, but really the intent is to ensure that if hard structures are to be approved, they are tested against alternatives and they do provide worthwhile benefits. I would just note that the NZCTS has sort of some clear policy about preferring to avoid hard structures where you can, and certainly DOC's experience in the freshwater regime is that hard structures can have all sorts of significant effects on ecosystems, habitat values, end effect erosion, those sorts of things. So, you know, I do consider that as important that there be some controls placed around where hard structures are used. So that's really the one point, and happy to take any questions.
Thank you, Mr. Brass. So,
yeah, thank you, Mr. Brass. Probably not really questions. I understand what you're saying. There's actually a test in there first before you get to reasonable alternatives. It has to be essential, and you're saying that's been removed. So it's actually the essential nature of it to locate there. That's gone. It just needs to be no reasonable alternative.
Yes, and that those reasonable alternatives reduce the risk and there's no quantum around what that reduction is.
Yeah.
So whether it's actually a worthwhile, meaningful, or justified risk, there's no consideration of that under that policy.
In the use of the word tolerate there, have you deliberately used that to link into that? I think those three categories around in the risk assessment process. I think they used the word tolerable somewhere.
No, my reasoning for using that was simply that was the wording on the original drafting. So on the clause 1 that's proposed to be deleted. So really, it was looking to pull the essential elements of both of them together.
Yeah. So the word tolerable was used in the risk table. Just wondered if there's any implications of that language. Okay, well, thank you for that.
I don't have any questions.
Yeah, my only question follows on from Alan's really around the use of tolerate or tolerable, and that I did ask Andrew about this morning, whether there needs to be a definition around that, or whether it should be referring directly through to App 6, because it's Appendix 6, which determines what's tolerable versus significant or acceptable. So whether when you were putting those words down, you sort of thought through that meaning in the wider context of what we've got in here.
I probably didn't, as I say, I was really looking to the language that was already there and pulling that through. I guess the key point there is that I'm not wedded to that specific wording for that reason. If from other evidence that you've heard, there's other wording that would achieve the intended effect, I would have no issues with that.
Yeah, and I see that's, it's wording that's already used. Okay, no, thank you.
Thank you, Mr. Brass. I have no further questions. It's all very clear. Thank you.
Thank you.
So the net wolf, was she appearing by? Yes, right. Kia ora, Ms. Wolf, are you with us as well?
Yes, yeah, she's just not got her microphone or video on. There we go.
Sorry,
Yeah.
I was just
There we are. We can hear you and see you now. Thank you.
sorry, I was listening to the live stream, but it must have been a bit delayed, so I didn't realise you needed me. But anyway, that's fine. So you've got my evidence in chief, and thank you for the opportunity just to present today, but there's only 4 outstanding matters in terms of the Hawke New Zealand submission and my evidence. And if I just talk you briefly through those, and you can perhaps ask some questions about them. The first one is about the method 2 for the district plan and the natural hazards section, where it requires councils to develop the natural hazard risk table to provide guidance, and also it includes clauses 7 to guide consents prior to the table being developed. The cost of the assessment will be borne by the applicant until such time as the natural hazard risk table has been developed and included in the regional and district plans. Given the importance of identification of the natural hazard risk to guide development in the region, there should be a reasonable timeframe established within which the risk table is developed and included in plans. And so my evidence supported some submission that there should be a time frame put in terms of when that risk table should be developed. The section 42 report states that the time frame is not included because the work is not identified in the Otago Regional Council long-term plan. In my opinion, it's important that the RPS is implemented, including through providing for work in the long-term plan. If a matter is significant enough for it to be included as a regionally significant issue in the RPS, then it should be included in the long-term plan and funding provided. So taking into account the 42A response, rather than seeking a specific date to be included in the RPS, I sought an amendment be included that sets a timeframe of 5 years from the RPS being made operative, within which to develop and include that natural hazard risk table in regional and district plans. And I consider that this provides an adequate timeframe for councils to revise their long-term plans to incorporate funding and for the work to be undertaken. Obviously, it's for the wider community or ultimately benefit by having the greatest certainty and clarity by the risk table being developed. Without a time frame included in the RPS, then this could linger for years. And I noticed there was a question from Commissioner Sullivan this morning regarding this, and I think it's appropriate to say how long should this work actually be taken. There are other timeframes set in the RPS for other pieces of work, and I consider that this is similar. And so my amendment that I sought was that within 5 years of the RPS being made operative, local authorities must work collaboratively with, and that's added to the commencement of natural hazards M2 clause 1. Another outstanding matter is the objective for contaminated land, which at the moment reads contaminated land and waste material are managed to protect human health, kaitahu values and the environment in Otago. And the Hort New Zealand submission and my evidence in chief, I raised an issue regarding the objective of protect for all the identified values and sought that the objective that's in the partially operative Otago RPS be used where the focus is not on not harming rather than protect. The 42A report rejects the submission because the NES for contaminated soils uses protect human health, and the objective is to shift to a more active outcome-directed management. I do not consider it's appropriate to apply protect all the values in the manner anticipated in the objective, especially when you look at the policy which implements the objective and you've got a differentiation between clause 2, which protects human health, and clause 3 for other matters. And therefore, I think that the objective isn't being given effect to because of the different policy structure, and we should equally make sure that the objective reflects what is sought. So in my evidence in chief, I sought that the contaminated land and waste material do not harm human health, whenua values in the environment in Otago, but it could be split, that contaminated land and waste material protect human health and do not harm kaitahu values in the environment in Otago. So it reflects where you head with policy 14. Another concern is regarding policy contaminated land policy 14 clause 3, and I noticed there's been a number of questions on this already today, and it really stems from the fact about hazardous substances being included in the definition of contaminated land. What I find interesting is that the relevant policy approach in the partially operative RPS is 465, and clauses 1 and 2 of policy 14 and the proposed RPS are the same, but clause 3 is different. So in the partially operative RPS, clause 3 is about minimizing adverse effects of the contaminants on the environment, while in the proposed RPS, it's on avoiding the adverse effects where practicable. And I'm not sure why some clauses have been rolled over and others haven't. And in my view, I think certainly that policy in the partially operative RPS was debated long and hard at mediation. And it would have been better, much better for it to have been rolled over in its entirety. The other concern about the clause, that particular policy, is there's no consideration of hazardous substances which may not potentially contaminate land. In the partially operative RPS, there was a specific policy around hazardous substances, but that doesn't exist in the proposed RPS. So there's a bit of a vacuum about how hazardous substances will be managed. And so I had thought that there was a potentially replacement of policy 3, but I actually now think that it's probably a new clause that there should be a consideration to determine whether significant adverse effects on the environment will result from the hazardous substances in or on the land. And that would cover off how hazardous substances were to be considered. The other outstanding point is regarding method 7 and some recognition of, and this is in the contaminated land section, recognition of the NES for contaminated soils. I thought that there was a reference to the NES in the method, and the 42A report considers that the implementation of the NES is in the NES itself. I note that the partially operative RPS includes method 426, which includes the reference to the NES for contaminated soil. And such a method makes it clear that the expectation for the district plan is to give effect to the NES. At present, there's no reference to the NES contaminated soil, and the method M7 is only about waste while achieving the outcomes listed in the relevant policies. I see no mischief by including reference to the NES in method 7, similar to that in the partially operative RPS. In my opinion, it provides clarity to plan users as to how the district plan will give effect to HAS CLP 14. And the changes I sought were set out in Appendix 1 of my evidence in chief. So happy to take questions.
Thank you. Tom?
No, I have no questions. Thank you. Your evidence is very clear on the matter. Thank you.
Right. You know, your evidence is clear to all of us. Thank you very much, Ms. Wolf. So thank you for the thought that you put into it, and there's nothing further that we need to raise with you. Okay.
Oh, well, thank you. And we'll see you next week in person.
Thank you. Right. Cool. Thanks.
Okay, thank you.
We're up to Mr. Place. Is he? Thank you.
Yeah. 1 second.
He's online.
It's connecting
Right.
slowly.
just possibly whilst we wait for this place, Mr. McKinnon, I asked you to look at those notes about whether or not it should be territorial authority or local authority.
Yes, and it should have been local authority rather than territorial authority.
In each of those two notes.
In each of those notes,
Okay.
yeah.
Thank you.
Your second question about the addition of P1A, me and Scott would prefer to think about that one a bit more. We think you're right, but we just want to make sure that there's no other consequential things we need to do. So whether that's in the reply report is probably the best place. So we have a clear understanding, we've covered everything.
No, look, I'd rather that you have the time to think it through, because as you say, there's so many interrelationships of the policies and methods. So no, certainly if you could make a note and ensure that that's addressed in closing, that's fine. Thank you. No sign, Mr. Place. There you go. Hello there, Mr. Place. Good afternoon.
Hello. Can you hear me?
Yes, we can. Thank you. And we can see you. Although you're a very, very long way from the camera.
Sorry, I'm just going to turn you up here. I'm just struggling to hear you actually.
Right. How's that working now?
Can you hear me now?
Yes, we can hear you well. Can you hear us?
Oh, very quietly. We'll see how we go. I've got it turned up here to maximum volume, so let me just see.
Right. Well,
perhaps that might be better. I'll crack
questions
on,
are asked, just
if you would like me to.
yes, look, as questions are asked, if you can't hear, then ask us to repeat, and we'll try and start shouting at you. All right.
Okay. Thank you.
Thanks, Mr. Place.
Turn it up on the TV here. Oh, that would be better. Okay. Good afternoon, Kieran's panel. My name is Luke Place. I'm a senior policy planner at Queenstown Lakes District Council. I've just got a brief statement, oral statement that I'll provide ahead of taking questions, if that's acceptable to you.
Thank you.
So I'm available today to answer questions on both the air and the hazards chapters of the RPS, for which QLDC has made a number of submission points and on which I've prepared evidence in chief and a rebuttal statement. And thank you very much for accommodating the change to my appearance in regards to the air chapter. My daughter was born on the day that I was due to hear I was due to be heard, so thank you for that. So the brief legal statements have been made for the panel to consider by Queenstown Lakes District Council's legal counsel. However, they won't be joining me today. So just quickly in regards to the air chapter, I primarily support the position taken by Otago Regional Council in the development of the chapter and the amendments put forward in the Section 42A report and the supplementary Section 42A report. However, I've only recommended a small number of amendments that are primarily focused on improving the practical application of the provisions themselves. In regard to the hazards chapter, in my view, the natural hazards chapter has the opportunity to provide critical direction in a time when natural hazards are impacting people, property, infrastructure assets, and communities more often and with greater consequences. And this has been brought into sharper focus with the recent events that have been experienced across the North Island recently. The Queenstown Lakes District and many other areas in the Otago region are located within dynamic alpine environments and subject to considerable development pressure. Therefore, it is important that the RPS provides this opportunity to generate clear direction on how to navigate this tension and to ensure good land use outcomes. In my view, the proposed RPS Natural Hazards chapter marks an important step towards a better approach to managing hazards in the Otago region. So I've got a number of amendments that I have recommended, but I am encouraged by the approach that has been proposed in the RPS. And if I could just take this opportunity also to correct one error in my evidence in chief on hazards. At paragraph 5.8, I refer most of the way down the paragraph there, I refer to limb 2, which I think should be remove everything but limb 2 should be removed. I meant to say limb 3 in that where it says, in my view, this constitutes all limbs except for limb 2. I meant to reference limb 3. Thank you. Have to say questions.
Thank you, Mr. Place. We'll start with Commissioner Cubitt.
Yeah, thank you, Mr. Place. Your evidence was very helpful, and I think today it's been further clarified with Andrew's opening. Have you had the opportunity to read Andrew's opening today?
I haven't had the opportunity to read it. I did look on the website to see if it was available. I heard the discussion, but no, I haven't had the opportunity to reflect critically on it at this point.
Okay, because your I'll find that when you're talking about table 8 in your evidence, which is I think 437 through to all the way through, really. He has recommended, you provided a couple of options here based on the ORC. This is in relation to, well, it's actually probably table 8. We have all these different table numbers in different documents, but it's the table 8 issue. He's recommended that quantitative assessment is required for the major and catastrophic consequence levels. Roughly align with what you have recommended, I think, without, except in relation to unlikely and rare in the major consequence. I think his recommendation is based on the ORC's evidence, but I was wondering whether that addresses your concern that may not go as far as you're seeking.
Yeah, I think it sounds like, from what I heard, although I would like to take a closer look at it and on paper version if that's possible in the first instance, but it sounds like that is moving closer to the QLDC submission and my position and my evidence. At paragraph 4.45, I recommend a number of changes to the note in relation to when a quantitative assessment needs to be undertaken. It's in regards to the note on page 288 underneath table 8. It's in regards to step 4. The second paragraph of step 4, I make some changes, I make some recommendations in regard to that reference in step 4, and I think I go a little bit further where I suggest that a total risk with a catastrophic or major consequence, or is a risk that has a moderate consequence with an almost certain likelihood, and I describe my reasons for that in my evidence and sheet. So it sounds like it's closer to where I have recommended.
Yeah, it doesn't get quite to what you're recommending, but I'm wondering in the context of that particular step in the appendix, that from my reading of it, that table was a sort of a placeholder until district councils and local communities develop their own table. So the reality is that if QLDC had a major concern around that, you could probably create that step yourself, couldn't you, through your district plan process?
Yeah, I certainly understand the philosophy and the structure of the RPS Natural Hazards chapter in terms of this being a placeholder. I was just thinking about this a little bit earlier, actually, in regards to the sort of use of the term placeholder. I wonder if it is sort of, does it materially represent what actually the RPS is doing with what it's proposed in front of us now? I think it is more than a placeholder. I think it's actually a really important approach that will be implemented and will make significant improvements to the way that we manage natural hazards up until the point where ORC and the district councils work together with communities to create this table to meet the community's needs. So while I accept that, yes, the approach may be modified in due course, I think I make comments elsewhere within my evidence that I do have concerns about the fact that it's not time bound, the methods and the implementation of a community specific table 8, I suppose, if you want to put it that way. I suppose we aren't left with a clear understanding of when we will have the opportunity, whether it's in the next 6 months or the next sort of 6 years. You know, I'm not entirely sure when that process will take place. So in my view, it's really important that we get a best case scenario in the RPS as it is currently, in order to set ourselves in good stead for doing that specific approach in due course.
Yeah, okay, and that's an issue that has been raised, particularly by the last speaker, actually. So I understand that. The other question I had was in where you talk about NHP2 and the concern that you have there, where the implication of the change is that natural hazard risk will only be assessed in areas that are specifically known. And I'm kind of confused about your paragraphs that follow. We talk about that you believe that doesn't mean that all land use will be required to undertake a risk assessment, only where a natural hazard is present. I don't quite follow that, because you'd have to actually undertake the activities would have to undertake assessment to know if it was there, wouldn't they? Or what were you meaning there? I'm not quite sure. If they're not identified already, surely all activities would have to, under your proposal, would actually have to take an identification process to be able to assess risk.
Sure. What paragraph were you referring to? Sorry, I missed that.
It starts at 4.8 through to 4.12, and you refer to the submission by Hoarding Z.
Yeah, sure. So I'm just looking at that part of my evidence now. So I think one of the points I make there, perhaps at paragraph 4.12, I talk about the holding pattern or the placeholder, if we were to refer to it in that way. It's I guess reflecting on that again, in terms of, you know, we don't at this point in time, OIC and region and the district councils, if they were to work together identifying hazards, that process hasn't been undertaken at this particular point in time. So there will be situations where an activity requires consent, but the hazards may not be known. And I think that has also been picked up earlier in the day. I think there was some discussion around, you know, the degree to which the framework is nimble enough to respond to climate change and the quickly changing nature of how we understand hazards and how we are looking to manage them, the change in best practice, the change to legislation, whether it is nimble enough to respond to those situations. So yeah, I think I was more getting at the fact that it's a placeholder structure, and that we need to make sure that, you know, we're not closing off those opportunities in the first instance where resource consent is proposed in places. Many places, for example, in Queenstown Lakes District, where you know, we have a number of people doing commercial recreation activities, for example, in locations that may well be subject to hazards, but we don't necessarily know 100% at this point in time where they are or the extent to which they may cause risk to life. So that's primarily what I was getting at.
Yeah, okay, yeah, I understand that, but I guess it's probably a bit like we're considering landscapes coming up next week. Most district plans or most councils already have information on hazard areas now, regardless of what we're going through here. Same with outstanding landscapes and that. So not sure if it's as big an issue as being made, given that there is quite a big base of information where these things are known, which should probably act as a bit of a guide for what may else be and what else may be in the area.
Yeah, I certainly take that point. I mean, we do know to some extent the locations. It's primarily focused on in and around sort of the urban areas largely, I would suggest, in terms of where the hazards are present, though. We know a bit about, I would suggest that we know more about where hazards are in more urbanized areas or areas that are on the urban fringe, as opposed to areas that might be perhaps within the rural environment where, maybe out of the box activities might be proposed that aren't necessarily anticipated by the plan. And so, or by, the hazards information that we have currently to hand. So I suppose that's the circumstance which might fall outside of that box.
Yeah. Yeah, and I guess in that existing activity policy too, you're talking about, I was interested in your evidence in section 5 around removal of subclause 2 there, and you identified a couple of definitions that's come out of the Australian Geomechanics Society practice note. What is the relevance of those to the RPS? Because they tend to be quite specific to earthworks.
Yeah, you're right. So I suppose the relevance of them to the RPS in this instance, I suppose there's a couple of points. The first is that we have a natural hazards management project that I'm involved with quite intricately at the moment, which has leaned on the Australian Geomechanics Society framework for assessing risk quite heavily. And so I suppose it's an example that I'm sort of, to a degree, from a planning expert's view, experienced with, and it's worked quite well for landslide. The landslide hazards that we are dealing with being rockfall and debris flow in this particular example near the Queenstown town centre. And that, my evidence talks about why that project is relevant to the RPS, and I won't go over that right now, but I hope that was made clear. I suppose the other reason why it's relevant is because the RPS hazards chapter, quite usefully tries to set out a framework for managing existing as well as new activities, and it assigns a level of risk, AIFR, or annual individual fatality risk level for existing and new development as well in that step 4 of APP6. So I suppose the purpose of it was to try and bring some context to what an existing activity is and what a new activity is, because I'm not necessarily sure that it's entirely clear all the time. And it's not until you've sort of had to deal with trying to define what is a new activity, what is an existing activity, and how should they be managed. And there's sort of more nuanced things to it, which mean, is an alteration or addition to an existing activity a new activity, or is it an existing activity in and of itself? So I suppose,
yeah, and your 5.7, you're seeking clarification from the ORC experts around that. When I look at those definitions, they're very narrow. So whether they'd work in all circumstances, but I guess you're looking for any help you can get, I guess, in that sense.
Yeah, that's right. And I think the main point is that we try and generate an RPS that is as helpful as possible for dealing with these really complex and messy natural hazard challenges, because we exist in an environment where we haven't got any guidance from central government on this, or very little, and insufficient guidance, and where there's very little experience of dealing with this sort of issue. We've talked about a couple of examples earlier in the day around Matata and Christchurch as well, in the Port Hills area. So what I'm trying to get at, I suppose, is if we can work towards a really unambiguous RPS chapter with regard to natural hazards, it's going to result in really good outcomes, which is what we all want, I think.
Okay, well, thank you very much for that.
Yeah, thank you, Mr. Blaze. I'm just checking my questions. I think most of them have been covered off. Just at your paragraph 4.21, where you're talking about rare landslide events with a recurrence interval of up to 100,000 years. I was just interested if different types of hazards generally would have different likelihood descriptors. I mean, your sort of comment is that the rear and the RPS is possibly isn't go far enough. Is it? I mean, is there something different for rockfall and debris flow that you've got a recurrence interval of 100,000 years for rear in your assessment?
Yeah, so there is the Australian Geomechanics Society landslide planning guidelines do set out recurrence intervals that are used in a risk assessment methodology, and they are a lot more less likely rather. So they do extend into the 100,000, and I can bring it up, I've got it on my computer here, but they do extend into really long recurrence interval events, but those events also have incredibly high consequences. And I think, so for that approach for landslide hazards in the Australian Geomechanics Society example is quite useful to use. And I think you're right, there is possibly, I think we could advance this methodology to be more sort of upfront with people about how they need to assess hazards by perhaps looking a bit harder about what likelihood ranges should apply to flooding, what likelihood ranges should apply to fire hazard. Should we use the AGS example for landslide planning, like tsunami SAISH rather, or tsunami and SAISH type tsunami and the likes of Queensland Lakes District. So yeah, and I wouldn't profess to be an expert in trying to understand what exactly each of those sort of likelihood ranges need to be, but what I've sort of suggested in my evidence is that perhaps there is an approach that we could apply on that basis. And I think I referenced perhaps the another RPS, which wasn't coming to mind, but I have written down my evidence. Bay of Plenty at paragraph 4.25, they used a similar approach to what I suggest by identifying a starting approach likelihood range as opposed to specifying it needing to be applied to every type of hazard. So it provides for a degree of flexibility as to what is the appropriate range of likelihoods for a particular hazard. So perhaps that's an example that could be employed in the proposed RPS if it advances better outcomes in terms of risk assessment. I think there is an opportunity to maybe provide some more specificity in there, perhaps along the lines of Bay of Plenty Regional Council. But I'm certainly open to advice from the likes of Jean-Luc Ion from ORC, who's a natural hazard specialist, or perhaps Scott Kelly from GNS on that front.
Yeah, okay, no, that's helpful.
I suppose if I could just add to that, if I do have the opportunity, is that as we learn more about the effects of climate change on different types of natural hazards, that approach will also build in some flexibility into the likelihood table. So that's just another point.
Okay, no, thank you for that. All my other questions have been covered off, so thank you for your evidence.
Thank you.
Thank you, Mr. Place. Just a few questions if I can. Just at the bottom of your at the end of your paragraph 4.12, it's probably a similar issue to Mr. Cubitt had a discussion with you about it, but you said, I consider clarification is needed as to whether all areas subject to natural hazards will be known both before and after ORC has undertaken its identification exercise. Let's just look at before the identification exercise is taken, and you say, I consider clarification is needed. I'm just struggling with that. I mean, the only way of clarifying it is for the exercise to occur, isn't it?
Yeah, well, I suppose that's one way of looking at it. I suppose I was more looking for a understanding of if the approach set out in the RPS is sort of going to be fit for purpose for all circumstances. And I suppose it's difficult for a planning document to sort of anticipate how every sort of proposal will come about. But if it can be as thorough and as unambiguous as possible, then we should aim and strive for that. I think, yeah, once again, what I'm trying to get at there is a really good approach to managing natural hazards, particularly in a district like Queenstown Lakes District, where we're constantly, learning more about where our natural hazards are, the extent to which they interact with people, and if there's situations where a resource consent is proposed that brings a bunch of people to a particularly hazardous location that's out of the box or somewhere that we didn't anticipate in the rural environment, or perhaps not even a rural environment, perhaps just in a new area that has suddenly become incredibly popular for tourist related reasons, then we should make sure that that location is going to fit within the framework. So I think, you've probably made the point that once the exercise is undertaken, if it's undertaken robustly and at a scale that is sort of relevant to the district, and particularly our district, then once the exercise has been undertaken, we should know robustly where the hazards are within the district. But ahead of time, I think there is some sort of grey area in that space.
Ms. Wolf for the Horticulture NZ just advocated to us that there should be a time limit for that identification process to occur. If in terms of M3, for M4, the requirement in respect to district plans requires that sort of identification process to occur. If we were to accept her proposition of a time limit of 5 years, how realistic would that be for Queenstown Lakes?
Yeah, I think a time limit is certainly something that should be looked at very seriously in terms of making, working towards certainty both for local authorities and for plan users, and for people who know, in the case of Queenstown Lakes District, that they are subject to areas of really high risk, and how that will progress over time. So I think that is really good from a plan certainty perspective. In terms of five years, that's a really good starting point, I think, for I suppose if we were to look at the complexity involved in the process of identifying hazards at a regional scale and undertaking, framework risk assessment on the scale that is set out in the RPS, I think it is a really big project. I think it's going to require a lot of resources. I think it's limited resources to undertake that project, and I think it's going to be reasonably expensive. So I think 5 years is probably a good starting point. I'd like to see it done as soon as possible. So if we could make it a bigger priority than that, that would be fantastic. But I work in local authority environments. I sort of know how much work is on. So I think 5 years is a really good starting point. And I think there's a lot of work that's actually already been done by the territorial authorities and the ORC in this space, and perhaps there's, if we were to look at prioritising, perhaps we could get rather than just stating a blanket 5 years, perhaps the time frame for doing the work could be prioritised. So, for example, urban areas might occur ahead of rural areas, or areas that are subject to future development strategy, or future urban areas, or something along those lines. We know that areas, particularly in our district, are subject to really high development pressure. Those areas could be prioritised and maybe done ahead of 5 years. So I think if we could work something in that way, that would make it a more nuanced approach and more responsive to the issues that are faced within the districts in the region. I think that would possibly be a bit more targeted, a bit more effective.
Yeah, are you really saying that at least the significant sites should be identified within a period of 5 years on a regional basis?
Yeah, I suppose so. Yeah.
Just a couple of points of clarification, if you could, for me. 4.21. I must be slow. I read your 4.21 and thought that what the outcome was, if you compared the AGS methodology with the AP6 methodology, that the AP6 methodology in respect of those rare events was actually more conservative, but then I got down to your last sentence and it said this ultimately means the AP6 is a less conservative approach. It's talking about a return frequency of 2,500 years being a rare event, where the AGS one was a recurrence of 100,000 years.
Yeah. No, look, it is, so I think what I'm getting at here is the relationship between the likelihood table and table 8 is the bit that is, I suppose, it's quite tricky to sort of translate that into really easy to read sentence, I suppose, because this is a really complex area of planning practice and geotechnical engineering, etc. So what I'm trying to say is, because of the fact that, for example, a 100,000 year event isn't in the likelihood table in the same way that it is in the AGS. And when you combine that with the colours in table 8, it means that those really long recurrence interval events with really high consequences are still tolerable. And then when you, in the QRDC risk assessment example, it means that, you know, at a location that has a risk value of 1 × 10⁻³ or 4, in the real life example that we've undertaken, it wouldn't be considered significant despite the fact that the step 4 does classify it as significant. So it's actually not just a single point in APP6, it's actually across the whole step process, if you like. So it traverses all the steps, and you have to think of them together, I think, in order to sort of comprehend what I'm trying to say there, if that makes sense. It does result in APP6 being less conservative because it doesn't account for those long recurrence interval events it doesn't identify them as being significant. And in this real life example that we've done in our district, you know, it should have been identified as significant, so that's why it's less conservative.
Yeah, I take your point. So you're saying that you've got to look at the combination of all of the factors in the various tables to see what the outcome is.
Yeah, it's sort of quite difficult to think of the steps in isolation, and yeah, it helps to have that real life example to work through.
Right. Looking at your paragraph 4.29 and 4.30, just in terms of the way this would operate for resource consent applications.
Yeah,
I struggle a bit with your middle sentence. It's not clear how AP6 can be completed for resource consent applications if matters 1 to 11 of step 2 are utilised alone or in isolation of table 7. But when you look at note 2 above in your paragraph 4.29, the matters listed in 1 to 11 provide useful considerations, we're now told, local authorities, and are the primary considerations. So there's no suggestion that there's a limitation to those alone, is it?
well, I suppose it doesn't say that explicitly, but if I was a resource consent applicant or perhaps a consultant looking at preparing an application, I think if that is the intent of note 2, as you've suggested, then I don't think it's a helpful note, because it shouldn't say that. I think it should be clearer as to the fact that, you know, 1 to 11 are something that should be considered second, not primarily. So I think that's where I get to as an alternative. In my evidence, I talk to, you know, how it could be modified in a way so that wasn't the case. So that if that is the intent of the RPS at step 2 and there's note 2, then that's fine, I suppose. But we need to make it clear if we plan users that, you know, table 7 is the primary method by which we will understand the severity of impact and therefore the consequence, because in the absence of a severity of impact classification, you can't, you know, if you were just to use 1 to 11 in isolation, they don't necessarily provide you with that answer of a severity of impact. And that's what I'm trying to get at, because then we can't progress to step 3, which is that really important point at which we decide if a qualitative or quantitative risk assessment is required. So it's just a matter of making that clearer if that's the intent of the RPS.
Just looking at the comparison on that last, on step 3, the coloured, in other words, the coloured risk table, table 8, and comparing yours with what's now been recommended to us, the only areas of difference in terms of consequences major, in terms of likelihood, unlikely, and rare. Given that these quantitative assessments are going to be complex, cause delay, and going to cost a large amount of money, is it reasonable to require them when the likelihood is unlikely or rare?
Well, I suppose you're balancing up the consequences of an event versus their likelihood, and so we need to. It's not an easy sort of threshold to make. But I think Mr. Kelly might have, or perhaps Mr. McLennan might have referenced earlier that we need to draw a line in the sand, and you know, in my view, a consequence of many deaths or whatever the reference is in table 7 is something that we should be requiring a quantitative assessment for. I suppose it's also important that we provide a really good context around what likelihood is, because just because it's a rare or unlikely event doesn't mean it's going to occur once every X years or once every 100,000 years or whatever the likelihood that you put on it, once every 2,500 years. It's actually just a point in time in that year. And one of the really useful examples that we've applied in the case of the Brewery Creek and Reeves Lane Natural Hazard Risk Assessment project has been to use a person's lifetime as, there's a range of different ways you can display likelihood. And you could use it, for example, 1 × 10⁻³ 4, 5, which I know you said earlier is quite a difficult way of presenting things, and it is. You can represent it as 1 in X number of years, or in our case, we used it as chance in a lifetime. So chance, for example, and if a person was to live for 80 years, a chance as a percentage, what chances that they might be killed, for example, in a landslide, in a debris flow or rockfall event. So yeah, I suppose that's just that context around likelihood is really important. And when you look at the consequences of that likelihood, I think it calls for a quantitative risk assessment, in my view, because there's too much to lose, I think, for our community if we don't put really high bars on those really high consequence events. I acknowledge that another point you raised is the cost. Certainly acknowledge that it's a really sort of, I suppose, niche area of geotechnical sort of practice, let alone planning practice. And so there is a degree of cost that will be associated with, and I think it will be associated with more the pre region-wide exercise as opposed to the post region-wide exercise. And I'm not sure if that's what is anticipated by the regional council. Perhaps we could ask those questions of Mr. McLennan and Mr. Kelly, but I think once we've done the region-wide risk assessment, those costs I anticipate they'll be lower than they will beforehand, because we'll have more certainty around where the significant areas are, and so at least we'll be most of the way through that process, which I think is what Mr. Kelly referred to earlier when you asked him a similar question.
Right. Yeah. All right. Final question. Just your paragraph 5.4. You say that, and you've repeated orally, that it's not entirely clear what constitutes a new activity as opposed to an existing activity. But aren't we just stuck with the reality that we have to operate in accordance with what the RMA says about those? Now, I know that you say that, but there are practical difficulties about that because you're talking about scale and intensity and footprint, etc. But isn't that something that councils have to deal with throughout the country all the time?
Yeah, I mean, I suppose for example, are you suggesting when we receive a consent for an addition to a building, then that would be a new activity as it's defined under the RMA? Is that sort of what you're suggesting?
Well, it requires an assessment by a council when it receives such a proposal as to whether or not it actually complies with section 10 in terms of the existing activity or the existing use in terms of intensity, scale and footprint. And that, as my understanding is that, you know, virtually day by day throughout the country somewhere, there'll be a local council who's been since 1991 having to apply those sorts of assessments.
Yeah, no, I mean, I understand what you're saying. I suppose the tricky thing is with natural hazards, with planning for natural hazards, is that I think what we've been left with through the RMA hasn't worked particularly well, and I think that's been demonstrated over the last sort of 10 to 20 years of dealing with hazards and the unfortunately ambiguous nature that the RMA has provided us with for managing natural hazards. So I suppose what I'm trying to get at is if we can, even if it sits outside of the RMA, the RPS, I think I've suggested elsewhere in regard to a different matter, I understand, but if we can produce guidance on how we should be implementing the RPS consistently across the region, potentially in regard to how we manage existing and new activities, what are existing and new activities, and that would be good. Of course, it should be informed, you're right, by what the RMA says in regard to what is a new activity and what is existing activity. And I think you mentioned section 10, you know, that's sort of lightly off to the side, I think, with this one. But yeah, I'm trying to get across in my evidence and QLDC's submission, I think, overall, is that the RPS needs to be as helpful as it can be in regard to this really tricky subject. And if we can do that up front and in this process, rather than sort of battling it out later through resource consents and other plan changes, and that's just so much more efficient. So yeah, I'm not sure if I'll answer your question 100%, but right. So that's the overall theme.
I get the trust of what you say. So look, thank you very much, Mr. Place, and I don't thank you for the amount of effort and thought that you made us go into in reading your evidence, but it was obviously a very good exercise for us and very informative. So thank you.
Thank you very much. I appreciate your time.
And subject to that existing use matter that you discuss with us now, or
yes, now,
yep.
Fine. Hang on. So just to qualify the answer I gave you this morning, and the discussion around the Tata situation got me thinking about this a bit more and wondering how the situation was managed there. So section 10 existing use rights apply to land uses of the type that are regulated by district plans. Those existing use rights under section 10 do not arise in connection with regional rules and regional plans. Those are governed by section 20A. And under section 20A, there is the ability to remove existing use rights. And as I understand it, that reflects the distinction between having lawfully established a use such as can I build a house here versus something like I'm having effects on biodiversity or discharging or soil quality and things like that. In the Matata instance, and I can send a copy of the Environment Court decision if this would be useful, what happened is that there was variation to district plan to prohibit any more building of houses in the relevant area. It was well understood that there could not be a change to the district plan to prohibit or take away existing use rights. That was achieved by a variation to the regional plan, which prohibited residential use of that land. So the scenario that arose from that is that you bought or built a house in that area, and a regional rule was created saying essentially that from a certain date you're no longer allowed to live in it or occupy it. That was the subject of a consent order by the Environment Court. As you might imagine, the regional rule change was appealed. Parties managed to reach agreement, and the Environment Court in that consent order context was satisfied that a rule of that nature was lawful. As context, it's important to note that a part of that package was the council offering to purchase each property for its full market value.
I was just going to mention it.
And so please don't take me as saying that my opinion is that there is a clear and obvious power to take away existing use rights of that nature, because that's not my view. It's simply making sure I didn't mislead this morning by pointing out this example and the way in which it was achieved. I can pretty much guarantee that if there was a regional rule promoted here which took away the right to use all coastal properties in Otago, it would receive the attention of not only the Environment Court but also other jurisdictions. And there would be a significant issue as to whether a rule of that nature is lawful.
Did the Environment Court, was it a determination, decision, minute, memorandum? Do you know?
It was determination.
Order.
I've only scanned it. So I see that there was a brief hearing held, but whether these issues were argued at that hearing.
Was there a reference to a particular part of section 20A?
20A didn't, well, it's not mentioned in the decision, but the relevant function is mentioned, which is section 31C. Which is the control of use of land for the purpose of avoidance or mitigation of natural hazards.
Right.
And so the court must have been satisfied that that function is broad enough to make a rule which says residential use is now prohibited.
Right. Well, thank you very much, Mr. Anderson. Yeah. And that's excellent. Thank you.
Thank you.
Right. Well, we've concluded today and start again at 9 o'clock. Bye. Thank you.